I will now call the House to order. Let us take up question number 1. Question raised by Livingstone Karpran, MLA, and Chief Minister to reply, please.
Mr. Speaker, sir, reply to star question number 1. A, sir, the total number of consultants appointed by the government are 36 individual consultants and 59 consultancy firms. B, sir, the total annual expenditure on monthly remuneration for individual consultants is 4.35 crores for the year 2024-25. Consultancy firms are typically not paid salaries or monthly remuneration like government employees. They are paid consultancy fee, which is based on deliverables as per contract.
Yo, parliamentary question, please.
Thank you, Mr. Speaker, sir. I should thank the Honourable Chief Minister for the reply.
Sir, not able to hear you, sir.
Thank you, Mr. Speaker, sir. The Honourable Chief Minister for the reply. I have 5 more supplementary questions. May I know from the Honourable Chief Minister, what is the mode of appointment or engagement of these consultants?
Sir, the different projects or different agencies that are engaging the different consultants, be it individual consultants or be it the firms that are there. So there are processes where sometimes it is through tendering process, where firms come in and they bid together and they apply, and based on the different factors of the process, the QCBS system or other factors are put into place, based on which the consultants are appointed in terms of the firms and individuals also, sir. There is a recruitment process that takes place where interviews are done, if necessary exams are also done. So there are different processes that are followed, and these are all mandatory and required. So therefore, these are the methods of the recruitment that is done, sir.
So, how many departments require such consultancy? Whether the government officials themselves are not competent to do the job as the consultants are doing?
Sir, I must thank the honourable member for asking this question. So this is a very, very important question, and I'd like to reply to this to the satisfaction of the honourable member. So number 1, he has mentioned about how many departments there are there. So when it comes to the individual consultants, there are 10 departments that are engaging individual consultants. And when it comes to consultancy firms, there are 13 departments that are engaging the consultancy firms. So second part of the question which honourable member has asked is, are the officials not competent enough? Sir, everybody is competent and everybody has a role to play. Everybody has a defined area of expertise. When we talk of consultants, a consultant technically is an individual or a firm which has a certain expertise in a certain matter. Now, so when it comes to appointment of these consultancy firms, most, I should say all the externally aided projects, all the externally projects, and a large number of centrally sponsored schemes and projects. So for example, the EAPs, about 12,000 crores worth of EAPs are being implemented. And in terms of large projects like the Smart City project or the recently Sora tourism project awarded by donor ministry. So these processes or these projects or these schemes, they make it mandatory. I use the word mandatory. It is part of the process. It is mandatorily defined by the externally aided agency or the specific central government to appoint consultants. And as I mentioned, sir, consultants are experts who are, in that particular field. Our officials are obviously, sir, very good. They are very efficient, but they are administratively expert. A political leader also may have a certain knowledge of the political aspect. But then when it comes to aspects, for example, so just so that the House knows, the mandate also requires, for example, we had just sanctioned 2,500 crores for the second phase of the World Bank MITP. So that required an environmental and social expert in the externally aided project. Now an environmental and social expert has to look at the environment and social impact assessment. That firm or the individual has to see environmental and social management plans. The same firm has to also look into the resettlement and action plans. They have to look at the indigenous people's development plan. They have to look at community consultation and so on and so forth. So these are very highly specialized areas where these requirements are made. And as I said, it is mandatory as per the EAPs as well as a large number of the central schemes. So also I just want to share so that people are also aware that these are not government jobs. There is a thinking that these are government jobs being taken away into consultants. So these are not government jobs. Government jobs are government jobs. These are the mandated expertise that are required as per the project guidelines being given, which we need to do. Number two, as I said, so these are specialized jobs. These are jobs which a normal team in the administration who are expert in administration and bureaucracy, they are not able to look into these aspects, as I said, like the environmental aspect. So the third and most important thing is that in the individual consultants that we have, a large number of those consultants are our own local boys and girls. And therefore, if you look at, not consultants, but like the projects that we get through these consulting agencies, which are then implemented by MBDA or MBMA or any other agency. Today, MBDA, sir, they employ 1,500 people. They are employing to implement these projects, which these consultants helped us, identify, build up, and bring. And 12,000 crores worth of project is going on today in the EAPs, because of which 1,500 jobs have been created in MBMA, MBDA. And you'll be happy to know today that 99.9% of them are all local boys and local girls who are working in these different projects. So you'll also be, there's also the House should know that EAPs, they have a scope of 5%, up to 10% of the funds being used for administrative expenditure. It is mandated again, sir. So that means 12,000 crores of externally aided projects are going on, which means 5% of that is 600 crores can be used for administrative expenditure. So these are not money that is coming from our own taxes collection. This is externally aided funds that are coming in. And the consultancy expenditure on a whole of whatever we spend, sir, 87% is today taken from the externally aided projects. So if you're spending 100 crores a year, for example, 87 crores is spent from the externally aided projects, which is funds coming in from outside. So these are the few things which I thought should clarify so that the House is understanding that these are not government jobs, as I said, these are additional experts that are required and mandated by the EAPs and central agencies for us to implement those projects.
Sir,
Next question, please.
so we have so many MBA graduates from states. Are these MBA graduates are also qualified to be recruited as consultants?
Yes, sir. They are absolutely qualified. But as I mentioned, sir, earlier, that it's a special expertise that is required for different works that have to be done. Sometimes we need experts and consultants for agriculture-related work. Sometimes we need experts for health-related works. Sometimes we need experts for power department also. Even in areas of education, experts are required. So, sir, when we say consultant, we always think that a consultant is only a administrative or a management consultant. That's what we tend to think. But consultants are subject-wise. There are consultants/experts for environment, for water-related issues, for agriculture-related issues. These are all consultants only, sir. So, therefore, an MBA is definitely qualified, and they would be there for a management-related consultancy. But that same MBA may not be able to do the consultancy work when it comes to, say, environment-related issues, because for that we need an environmental expert. So therefore, if there's an environmental expert, then we definitely take in. Now, just to share with the honorable member, sir, that in the beginning, as we started off, we were building the capacity of the department, of the agencies, and of our people, sir. And it is because of the expertise that we were able to put in that we were able to leverage and get schemes from central government and from the EAPs. Today, sir, we are one of the few states to get the highest number of externally aided projects because of the expertise that we took on board. We are also one of the few states to maximize the central government agency schemes. So the project in Sora, worth about 200 plus crores, there was only one project the whole donor ministry was going to give to one of the states in the northeast. It was like a competition almost. And because of the fact that we were able to put in experts and the local, our officials and the tourism team, they worked together with experts. In time, we were able to deliver and get the 200 plus crore projects. So therefore, sir, it depends. The answer is yes also, that they are capable and they can, but it depends on what expertise we require. And to conclude to this reply of this particular question, that today we have 36 individual consultants who are there, and out of these 36 individual consultants, sir, 52%, 19 of them are our own local boys and girls, our own MBAs, our own ex-officials who were there who maybe have retired, or our MBA students, or agriculture experts, or environmental experts, sir. And as we move along, we are ensuring that the capacity of our youngsters is built up through the entire ecosystem, so that more and more of our youngsters can become capable to then take on this responsibility that requires global expertise.
Thank you, Chief Minister. Whether the government used to conduct any performance assessments of these consultants? If so, please give details.
Sir, as I mentioned in my reply, that the consultants are paid based on deliverables as per contract. So therefore, once they deliver something, for example, if the DPR has to be made within 2 weeks' time, that deliverable will have a certain amount that has to be paid to them. So therefore, sir, their basic assessment, I should say, is on their own, because if they don't perform and they don't deliver, then they don't get the kind of fees or the money that is being put in the contract. So everything is in the contract, and they have to deliver as per a thing, and based on how they deliver, what quality they deliver, on the time they deliver, as per terms and conditions, they are paid. So in a way, so the contract only becomes a mechanism of ensuring that that the payments are made as per the deliverables.
One question, sir. May I know whether the consultants engaged by the government are performing advisory role only, or whether they are carrying out duties that are normally assigned to regular government officers?
Sir, again, the project-to-project basis, the different aspects are there. But in most cases, sir, the project, the work that happens is, of course, the preparation of DPRs. So that is one of the parts that they do. The second important aspect that they do is what we call the environment and social experts. That is the second part that they do. The third is they work in procurement. Again, procurement is a very complicated step. Agencies like the World Bank, ADB, they are very, very particular about procurement policy. And hence it has to be done in a very, very expert manner as well as, in details. Then the PMU, they also act as PMU. So they are the project management unit. So therefore they check into the different aspects of the project, whether it's being implemented on time or not. Because again, it's mandated by the funding agency that requires us to have them as PMUs. And then, and contract supervision. So in the contract supervision also is part of the work. Again, so these are all aspects which are mandated by the funding agencies for that particular project. It's not something that we have come out with. So therefore, it's all depends on project to project, funding to funding, and based on that, Government of India or the funding agency defines what that funding should be or what that particular aspect should be. And obviously, sir, at the end of the day, the responsibility of the government officials is always the power or the mandate that's been given to government officials. That cannot be taken away by anybody, sir. The particular official at that particular post or level has been given the power and mandated by the government. So the agency comes in and in technical terms, so just to summarize, at the end of the day, plays a role to support the system. And we can use the honorable member's word as an advisory, but the advisory also, as I said, goes into these 3-4 areas that I mentioned of a DPR, environment and social aspect, procurement, PMU, construction supervision. So it depends on all of that. But the primary role is to support the system and not to take over the system, not to interfere with the system, or not to be there to take the responsibility of government officials. They have the defined role, sir, and they go as per the defined role.
So we move on to next question. You have not raised your, okay.
Working down. Sir, in the course of reply, the Honorable Chief Minister said that Meghalaya has received the highest funding in external aided schemes. So may I know whether this highest is among the entire country or among the northeastern states, sir?
So the amount is about 12,000 plus crores. It is, I should say, among the smaller states in the northeast, it is the highest, way, way above the rest of the northeastern states. Most of them, that is. Maybe one more will be there that is somewhere close to us, but otherwise way above the rest of the northeastern states. And we are also at almost at par at what the larger states and the bigger states are able to absorb. Sir, again, just so that the house is clear, that when we talk of big projects, sir, there is a lot of work that goes into these things. You need the capacity to be able to present what you want to do, and you have to have the capacity to absorb the money that has been sanctioned. Both of this requires a lot of efficiency in the system. And therefore, Meghalaya has been able to present itself and also work in that manner. And that's why we've been able to get these funds. But to answer the question, sir, yes, we are definitely the highest among the small states, and we are at the league of a large number of states, at the largest states in the country, sir.
Okay,
Mr. Speaker, sir, though enough time has been taken for this start question number 1, in view of the importance of this question, I would like to seek some more information in respect of the purpose of this consultancy who were appointed. We understand very well the purpose. Now, in view of these different numbers appointed by the government, which reflects 36 individual consultants and 59 consultancy firms, in respect of the various proposals that is expected to be prepared by these consultants in order to post them before the different line ministries, Government of India, for the purpose of availing programs under EAP. May I seek this information to be placed on the table of this August House in as far as the proposals which have been successfully prepared and posted to different line ministries and their fate thereof from the time of their appointment till date.
Yes, sir. I have some of the information with me, and if the honourable member would like to know that, but it says that the list is long. I can place it on the table of the House. So we'll do that. And it's a good number, sir, so just to share with you, and it's something that yeah, yes, sir.
To cut down. But Paul, Lindo, please.
To know whether there is a mandatory inbuilt disclosure of interest clause to ensure that no consultant is working for a firm that is bidding for projects in the same department that they advise or are consultants to.
So this is more technical in nature. I don't want to comment without going through the facts. But in most of the cases in such contracts, these kind of clause of conflict of interest is definitely part of the agreements that are there. So it would not be advisable and not be appropriate for government not to have that. So therefore, it should be there, but I would definitely seek more time to reply to that. But as I said, it is a natural process. It's a natural process. It must be there. It should be done, and I'm very sure it is part of it, sir. But as I said, without getting the exact details, I would not. But as I said, the information, whatever is with me, is that it should be a yes. But as I said, I will come back with all the details, sir.
Yes, Baba Stable.
Thank you, Mr. Speaker, sir. I would like to know from the Honorable Chief Minister, as per the information that have been replied by the Chief Minister, with regards to the annual expenditure on monthly remuneration for individual consultant is 4.35 crores, specifically for 2024-25. May I know from the Honorable Chief Minister, as far as the consultancy fee, which is paid to these consultancy firms based on deliverables as per the contracts. How much is the amount that has been paid to these firms?
So just one second, a lot of papers out here. Just try to... Ready? Oh. Sir, to the 59 firms, to the 59 firms that are there, the total amount that has been given is 131 crores. Out of the 131 crores, 116 crores is through the administrative expenditure permissible under the externally aided projects. So 116 crores comes out from the funding agencies' funds that come to us. Then there are, of course, other projects that are there where we require their expertise, where we have to fund from our side. So that from the state side, we have spent till now about 10 crores, 75,000, 10 crores, 75,000. And from central fund, we have spent 5 crores, 67,000. And from externally aided projects, 85% of the amount that has been paid to these firms has come from externally aided project funding, amounting to 116 crores. So total 131.73 crores.
Yes, sir. One last question. Only one.
No, two.
You have spent so much time on this
No, sir.
single question. Only.
I'm not the one who's spending.
Just one question.
Yeah.
Quickly.
Sir, two questions, please, because there is no such rule. I mean,
I
which
can
bar?
allow only two. Okay.
Yeah.
Please,
Okay.
fast.
Okay, may I know from Honorable Chief Minister, whether these consultants which had given I mean, through your reply. Total consultants is 95. Whether these 95 are there since the first day which has been appointed?
No, sir. Sir, as mentioned, these are not government jobs that remain permanently. Consultants are appointed on a project-to-project basis. So as the project comes, they are appointed, and as the project concludes, the work of the consultants and the terms are over then. So therefore, as we went along, many externally aided projects were applied for. So therefore, we picked up the consultants as we moved along. So it's not that from day one they've been there. And that is reason why we have seen that a large number of projects, from externally aided projects went through. So we are at 12,000 crores today. And a lot of the projects, as I said, the consultancy is mandated, sir, in the terms and conditions of these EAPs. Just to give another example, in the SORA project also, where we got 200, we got consultants as per the mandate, and we got that project sanctioned for Meghalaya. Similarly, sir, a project like the Smart City. Similarly, projects like the Unity Mall. So we were one of the first states to get the project submitted, as well as the first 3 states to get the sanction of Unity Mall, because the consultants were there. So therefore, so consultants are a critical part, and they are there as per the mandate, and they are appointed as per the lifespan of the project, and they are project to project basis. They are appointed when the project comes in, and it's over when the project is over.
Mr. Speaker, sir, one more question, please. Through you, Mr. Speaker, sir, I would like to know, like what the Honorable Chief Minister had replied during the course of his reply, when questioners, Honorable Member from Mauringkaning had asked about how is the criteria or policy for appointing these consultants, whereas Honorable Chief Minister had replied the after effect, I mean the after appointment. But he do want, and myself also, and I hope every one of us, we do want to know the clear criteria that how is the procedure taken ahead before given appointment, before appointing the consultant.
Sir, again, there are a lot of confusion as to, I think the whole word consultants. And again, as I said, I repeat, sir, that consultants are of different nature, and the point is, sir, that there is no defined process for a consultant. The general process is there, and but the requirements differ, sir. For example, if I require an expertise for environmental and social risk assessment, then the consultant for that and the advertisement for that, process for that, the tendering for that will have different terms and conditions. If I require an expert or a consultant for agriculture-based, somebody who will study, bud rot disease, or somebody who will study the overall possibility of expansion of, shiitake mushroom demand in the state, then will require marketing and agriculture expertise. So it all depends based on the project's needs. But the process of interview, process of, say, an exam if necessary, process of presentation and tendering process. So these are standard operating procedures which need to be followed as per the mandate of the central agencies, central government, as well as externally aided agencies. So there is a defined process. And as I said, I just want to be short in this, sir, that the interview or the exams that have to be held, again, case-to-case basis, or the tendering, the process is defined, sir. And if we have to follow those processes, we cannot just simply appoint anybody that we would wish. There's a process of doing it, and then the selection is done on the basis of that.
Thank you. Now we move on to question number 2, raised by Sri Nujoki Sumo MLA, Minister in charge to reply, please.
So, answer to star question 2. So, the DPR shall be prepared immediately on receipt of the land required for construction of various components of the project.
Yes, your supplementary questions, please.
Thank you, Mr. Speaker, sir. So I would just like to know from the Honourable Minister, what is the total number of household and population in these 3 villages, sir?
So, it's 4 villages: Mukayu, Motursia A, Motursia B, Mukap. So, total number of population as per the census to 2011 is 9,058, sir, and household is 1387.
Sir, it has been more than 10 years now, since 2011 census. So as per the record that is available with me, the total number of household is more than 2,300 and the total population is nearly 15,000, sir. So, sir, another supplementary question. I would like to know from the Honourable Minister, sir, what are the different components under this proposal, sir?
So the different components will be, construction of a dam for the intake point and water treatment plant, sir.
Sir, why I raise this very important question, sir? Despite being one of the biggest habitation apart from Jawai in Jainti Hills, we are facing water crisis almost every year, sir. So I used to remember when we were still young, we used to wake up in the morning, early at 1 a.m., 2 a.m. in the morning, we used to fetch water, sir. So that's why, sir, till now, the problem exists till now. So that's why, sir, I would like to request Honourable Minister, sir, whether the government is actively considering to sanction this proposal, sir?
So yes, sir.
One more supplementary, sir. First of all, sir, I would like to thank the Honourable Minister for the positive response, sir. So since the answer is yes, may I know, sir, whether there is any specific timeline? Because till now we are suffering, sir, because of water shortage. So that's why, sir, if you can get a specific timeline as to when this proposal will be sanctioned, sir. Because I can assure the House, as far as land, there is no issue, sir. I can assure the House, we will get the land, sir.
I would like to thank Honourable Member for assuring the land issue. But as per the record here, sir, Executive Engineer has already called a meeting for this particular matter, for these land issues and all. But till now, the department has not received any land issues. So I would request you, through you, sir, Honourable Member, if he can pursue it at the earliest and send the NOC to the department concerned, sir.
Sir, why I'm saying this, sir, because recently the officer from the PHE department, they only met one headman, sir. So from the headman side also, he has already assured that there won't be any problem with regard to the land issue. So I can assure you that, sir, and we'll take the necessary step and we'll make the necessary arrangement for the land, sir. Thank you, sir.
Thank you.
Now we move on to next question number 3, raised by Dr. Mizanur Khaji, Minister in charge, to reply, please.
Mr. Speaker, sir, reply to start question 3. A, yes, sir. B, sir, the government is processing salary proposals through a portal called Meghalaya School Information Management System, MAXIMS, to eliminate the delay in submitting proposals through hard copy, sir.
Yes, Dr.
Thank you, Mr. Speaker, sir. Through you, may I know from the Honorable Minister in charge that what is the current status of salary disbursement And is there any delay? And if yes, then the district-wise amount of pending salaries.
So there is no delay in the disbursement of salary for the government teachers, but yes, sir, there is a delay in the other categories of teachers. As of now, sir, the salary have been paid till December 2025, sir.
Thank you, Mr. Speaker, sir. May I know from the Honorable Minister in charge, sir, that any principal causes that have been outlined for the delay in salaries of teachers other than the government teachers?
So there are many factors which contribute to the delay of the payment of the salary to the teachers. One is that the processing of the salary payment. This system, that's why the government come up with this new system, where through this Maxim portal, the process will be more simplified for so that the government could sanction at the earliest, sir.
Mr. Speaker, sir, is it a fact that these salaries for the ad hoc and granting aid teachers are diverted to some other causes? And if yes, is there any steps taken to mitigate this problem?
No, sir. There is no diversion of salary, which means for the teachers, it is paid for the teachers, sir.
Thank you, Mr. Speaker, sir. May I know from the Honorable Minister in charge that is there any recent cabinet decision wherein there is a approval for structured pay framework, and what is the present status of implementation and the timeline for the full pay rollout?
Yes, sir. As you have, everybody knows that the problem or the grievance of the teacher is the one of the major issue which bogged down the education department from time to time. But I'm very thankful to the Honorable Chief Minister and the Honorable Cabinet on the 19th of December 2025, where they have approved that for all the categories of these granting aid teachers, they will bring into one umbrella is that the new pay, structured pay framework for those fixed pay teachers. And the implementation of this new structure will start on the 1st of April 2026, sir.
Mr. Thaba, please.
Sir, such delays are affecting the moral and performance of our teachers. So I just want to know from the Minister in charge of Education, has the Education Department dedicated a specific or separate salary head to prevent future delays?
So the Education Department have the different heads for this salary. So for salary, so there is no issue with this. The only thing is that there is the issue is that during this so many years that we find that sometimes the delay is there. So that to streamline all these things, the government come up with this new system where we could check where is delay happen, and so that the burden or so that it will ease the mind of the teachers, so that they will get the salary on time, sir.
Okay. Mukul, please.
Mr. Speaker, sir, now this issue related to the salary of the teachers, there's quite a substantial disparity in respect of the salary which are being paid to different categories of teachers. Now, this issue has been a matter of concern, and it is only appropriate that we must take cognizance of this huge disparity and do justice to those categories of teachers who are being paid abysmally low. So I have not seen government taking steps to address this issue. So may I therefore, through you, Mr. Speaker, sir, get a categorical response of the government in this regard.
Mr. Speaker, sir, on the 12th of February 2026, the government issued one notification, whereby may I read the operative part of it, that Lower Primary School, 0 to 5 years, the revised salary is 21,000 plus CPF 1,680, it becomes 22,680. Then 5 to 11 years, 22,000 is the revised pay, and the CPF 1760. 11 to 19 years, 23,000. CPF 1,840. 19 to 28 years, 24,000. CPF 1,920, and about 28 years, 25,000. CPF 2,000. Upper primary, 0 to 5 years, 2,425, 24,250, CPF 1,940, total 26,190, 5 to 11 years, 25,300, CPF 2,024, and so on and so forth. These are we recognize the contribution of the teachers. This is disparity of the teachers. As you must have known, sir, we have different categories of teachers. We have SSA, LP and UP. We have RMSA for secondary and higher secondary. We have ad hoc teachers, LP, UP, secondary, higher secondary, secondary morning, secondary night. We have food teachers, we have science grant, secondary, we have Hindi teachers, secondary, we have pre-primary teachers, preschool. And there are different categories and different pay structure. I'm very thankful to Honorable Chief Minister that to ease the burden and to bring the parity in the pay. So we brought this notification, as I mentioned above, the education, that on the 12th of February 2026, which this pay structure will be implemented on the 1st of April. I hope with this intervention of the government that I cannot say 10%, but that the issue relating to the teachers' condition and salary will be eased to such an extent. Thank you.
Mr. Speaker, sir, in view of this reply, then what will be the total quantum of amount that is projected to be spent for this lower primary, upper primary categories and the other categories in terms of the annual expenditure that is projected?
Sir, I think it's important to understand, and of course Honorable LO will be quite aware about that. But just for the knowledge of the House, as correctly mentioned by our Education Minister, that there are different categories of schools. That's the most complicated aspect of the education system in Meghalaya. And if you look at this whole aspect, a lot of times in the past we have heard that why hasn't government paid the salary of ad hoc teachers? Why hasn't government paid the salary of, say a deficit school teacher or a college? Sir, we have to understand that there is government school and there is what we call not a non-government but not a government, a private school. The ad hocs and the deficits are actually privately owned or community owned or mission owned. They are not owned by government, sir, most of them, 90% plus. And when you look at these categories of schools which are not owned by government, they are owned by the private managing committee. So when you talk of the ad hoc schools, they are not government schools. So they are, with due respect, sir, say run by you, sir. For example, Mr. Thomas, school. And you are the managing committee. Government gives a grant. So all these years we've been giving what we call ad hoc grant to your school because you could not run it. So in the last 20, 30, 40 years, the consecutive government started giving, ad hoc grant to somebody. You pay your salaries. This grant took a structure of salaries after 10 years, 15 years, the nomenclature changed. Then the expectation happened that now this school that belongs to Mr. Thomas, you see, but government just has to pay the salary. We are paying grant and aid to you. We don't pay salary to you. But in 40 years' time, The teachers then and the society at large said that no, this teacher's salary of this ad hoc school, government is not paying. So, sir, this narrative that has come up, for whatever reason, sir, has led to this kind of confusion today. So, let's be very clear. Government schools is government direct responsibility. Ad hoc schools and deficit schools, SSA also is government's responsibility. But ad hoc schools are run by private sector. So this has to be very, very clear, sir. What we are doing today is, in spite of the fact that this is being run by by private sector, not owned by government, we realize the pain of the teachers. The teacher who is getting the ad hoc grant, we increase the grant per teacher to 18,000, example. Now, so what happens is, if you have been working for 30 years, you will also get 18,000. I have been working for 1 year, I will also get 18,000. The ad hoc teachers and the SSA teachers were stuck with a specific pay, no matter how experienced they were. And hence now, this is important, sir, to understand. Now what we have done is we have created one category for as many as possible. Sir, the minister has already explained to you the number of teachers we have, different teachers. We have 55,000 teachers, sir. So just to give an example to you, Tripura, which has got about 10 lakh population more than us, has got 40,000 teachers. We have 55,000 teachers. They have 4,000 schools. We have 14,000 schools. So this is the comparison and the fact that we have so many categories of schools, so many categories of teachers, and we realize that government has to step in and take a decisive step to somehow give structure to this, and that's what we're doing. To answer to the question of the LO, I don't have the exact number. I mean, Minister will first have the exact number, but I can give you a rough estimate that we used to spend approximately 600 crores for SSA and for ad hoc teachers in the LP UP category. And today, with this decision that we took, where now a structured pay will come in, the experience minister read out that if you are 0 to 5 years experience, you'll get 21,000 something. If your experience is above 25 years, then you'll get about 28,000. So we are giving that seniority also thing. We are giving an increment of 3%, is it? Yeah. 3% increment annually to every teacher. So they know that they have got growth happening every year. So we are going to be spending approximately 800 crores plus now. So there's an addition of about 200 plus crores. If Honorable Minister has the exact number, then he can also say it. But I roughly remember, sir, about 815 or 16 crores is what's going to come up. So you can say a net impact of 200 plus minus crores will be there. But this decision will lead to a kind of a structured pay system and a framework, and more importantly, a system which will give a security and safety to the teachers, give increment to them, and most importantly, sir, that will ensure that there is growth, and they can see increments coming up in the future. So it's a very, very tough decision, a very highly financially implicable decision, but a decision in the right direction, which will lead to a stabilization of the education system to a large extent, and 23,007 teachers, if I'm not wrong, 23,007 teachers will be impacted because of this decision.
Mr. Speaker, sir, there is some deviation from the original, how the whole educational, rather the whole effort of the community to establish educational institution at the primary level and upper primary level and secondary level, the overall involvement of the community in assuming this responsibility in absence of government initiative in the beginning. So there are two categories when we talk about non-government schools. One is which is established by the communities coming together in absence of government initiative. That is how every institutions have been established, first in the form of venture, then afterwards grant in aid, then afterwards deficit, then afterwards provincialization. That is how it has evolved over the years. Now, if we club other private institutions where we have individual your academicians who are coming together and establishing private schools. You have number of private schools coming up in different areas, whether it is in Tura, Williamnagar, even in the rural areas. Now, we have to segregate this part from the institutions which were established collectively by the community prior to government's initiative. Now, as they have evolved over the years, now how do we take cognizance of this contribution and somehow ensure that what is now in deficit pattern is ultimately converted into a government, so that at least teachers end up getting the same benefit which is provided to the teachers who retire from government schools. Now, primary schools, there are a number of schools which are in deficit. Now, these teachers retire and they don't get the retirement benefit. So, these are areas of concern. Now, this granite salary, if we say salary, then that means we are assuming that we are the employer. That's why we have made it a point earlier also that when we extend this support to the managing committee, which is drawn from the communities, then we only put a rider that as we provide this grant in aid or assistance, minimum salary should be ensured this much. Over and above that, how much they top up is up to them. So this is how we have managed. And if we deviate from this, we're going to have serious problem in future, because then you are owning all the teachers of even those which are yet to be provincialized. So I think I would request the Honorable Chief Minister to have certain discussion on this issue together.
No, what is the question, please?
I'm submitting this suggestion. I would ask the government to have a considered discussion on this issue, maybe in his chamber or wherever. We will be there, because this is going haywire.
Sir, the concerns of the LO, since he is not aware of the entire package. So number one, it's not salary. That's why if you notice, sir, I hesitated when I was speaking, when I talked about the pay structure. So we were very, very clear that the words we will use is pay framework, a structured pay framework. So the word salary does not come into the language, number one. Number two, sir, we are not here talking about all schools that are private or community run. The schools that are receiving ad hoc grant as of now, who are receiving ad hoc grant. Some are community, some are individual, private based. For whatever reason, in the past 40 years, different governments have started giving grant in aid to different ones, which came to be known as ad hoc grant, at least one of the grants. And here we are trying to resolve the ad hoc group. So this ad hoc, there are some schools which are community run, I mentioned that. Some are private run, some are mission run. What we are doing, sir, is that since they have formed an umbrella organization, they are part of one category of ad hoc grant teachers, or ad hoc teachers they call themselves. Of course, they have got 4 or 5 mini committees also, and groups under them. But I think it's a FASCOM, I think, is the umbrella organization. And they are the organizations with whom we've been talking. So they are, yes, correctly mentioned. Some are owned privately, some are owned by community and the thing. But what we are doing, sir, we are bringing a structured pay for these teachers as per their demand. So this is something they have demanded. Now, when we move forward with this, sir, we are not here to take over the schools. We are not here. And we have very clearly discussed with the teachers that this is the structure we're going to give you. If you're going to expect that it's going to be government scale, it's not going to happen. But we are going to give you increments at this level. The Commissioner Secretary and Education Minister must have sat maybe more than 7-8 times with them. We had engagement with them at multiple levels. Negotiation took place, came back to us. We went back to the negotiation table with them. So this was a long drawn exercise with the stakeholders themselves, which is the ad hoc school teachers. So we are here to resolve this ad hoc school teachers issue, which is about 7,000 numbers, sir, plus minus, and the rest are the SSS school teachers. So this is what we are trying to resolve here, sir. Deficit, of course, is the next step. We are working and seeing if there's a possibility. It's not easy, sir. Education system is super complicated. We are examining, sir. We would like to help everyone. But it's not an easy decision, because every decision has got financial and legal implications for us. So therefore, we were very clear and we said we are going to resolve right now this ad hoc and the issues that are there with SSA. So we are very, very confined to these two categories, and this is what we're going to work on. And as I said, the aspect of salary will not be there. So we will share with the Honorable LO as desired by him. I think it's a positive step that the government shares this information and discusses and informs them in detail what government is planning to do. And they can be obviously privy to that because the teachers already know about it. I don't see any reason why we cannot share. So we will share that information, sir, and I'm sure that they'll be quite satisfied and happy because the teachers, small issues here and there were there, but we have ironed them out. But the teachers themselves had, as I said, have accepted this, and as I said, it's resolving most of the issues that the ad hoc teachers and the SSAs have had, sir. So it's been a long drawn exercise, not something we decided in 1 week. For the last 1 year, this exercise has been going on, sir.
Mr. Adjournment, no, please.
Sir, since this is a concern, matter of concern of the whole state, as this matter deal with the teachers, let's not forget the fact that it is teachers who bring us to this position where we are today. So may I know, because every time and again we have experienced that teachers they have to come out to the street to agitate, to demand their right. Why this is happening again and again? So I would like to know from the Honorable Minister through you, Mr. Speaker, sir, we'd like to know the specific reason, whether the government has identified the specific reason for the recurring delay in teachers' salary payment. May I get a clarity from you, Honorable Minister, sir?
Sir, I have already replied that we have identified, that's why we have come up with a new system, but through this portal where the submission of the salary bills and all will be processed, and we will know that where through this system everybody can check that where it is lie, so for the immediate payment of the pay structure or salary or whatever may grant in aid as it is on time, sir.
So may I know, I would like to put a more supplement to you, Mr. Speaker, sir, to Honorable Minister. What about the teachers' deficit, whether the government of the day has any intention to revise the salary?
So the deficit teachers, they got the salary as per scale of the same as the government teachers, sir.
One more supplementary, sir. What about government teachers drawing UGC scales have been denied allowances since 1996, whereas those drawing state scale are getting the benefit. Have you aware about this? If you are aware, what action need to be taken by the government?
So the government is not deny the right of any people or any category of the teachers. Whatever we do is as per rule in place, sir.
Barini, please.
Will this payment structure contradict with the MEG proposal of the government?
There is no contradiction, sir, because the MEG, it is that the government is soliciting the view of different schools, different community which runs the school. So that is the discussion paper. So anything we do, it is in line with what we are doing, sir.
So we come to next question. Question raised by Sri Adan Miller Basomet. Minister in charge to reply, please.
Mr. Speaker, sir, answer to question number 2A. The total number of liquid units are 8, and the total number of ethanol unit is 1. B. The information regarding the products manufactured in liquid unit is as per statement placed on the table of the House.
Question hour is over.
Under Rule 282, may I be allowed to make a submission as far as the adjournment motion is concerned?
Under Rule
282.
Okay, yes.
Thank you, sir. So, though you have denied me the and not admit my submission, so I would like to make a submission today, sir. Because every time, sir, we find that the executive often uses sub judice broadly to avoid embarrassment, avoid immediate accountability, and to delay political debate. So, according to Article 194, powers and privileges of the state legislature. And as the legislature, we have the freedom of speech within the House and power to discuss matters of public importance. And even courts themselves, repeatedly held that legislative discussion is not barred merely because the case is pending. So, sir, unless it directly interferes with adjudication. So, sir, there are few areas which we are not supposed to be allowed to discuss, and there are some areas that we are supposed to be allowed. So we know that we cannot discuss guilty, innocence, evidence in court merits, and judicial findings. However, sir, we can discuss on administrative failure, policy lapses, and government negligence, and also preventive measures, sir. So, sir, I feel that the executive should not hide itself under this provision of sub judice. So I feel that whatever happened in East Giant Hills is a matter of serious concern, that all the members of this House should be given a chance to deliberate this issue, sir. So if, sir, you allow, then I think it will be for the benefit of the people of the state. The people of the state, they are watching, they want to know exactly what led to that unfortunate incident and the matters surrounding this illegal extraction of coal in the state, sir.
Earlier, Honorable Chief Minister had already made a suo motu statement in this regard, and I have also received that this matter is sub judice and cannot be is pending at a court of law and cannot be discussed. So, accordingly, I have taken this decision based on Rule number 57, subclause 6, and I stand by my decision, and the Speaker's decision is final. So we move on to item number 2.
Mr. Speaker, sir.
Calling attention.
Mr. Speaker, sir. The submission made by Honorable Member, it does give space to at least place before the August House certain submissions which are very relevant for the purpose of protecting the interests of the state and the people. Now, this particular instant case, which is recent in nature, and the responsibility of the authorities to take cognizance of this kind of illegality when it comes to the notice of the authorities. Refer to the Section 21 of the MMDR Act 1957. It should have been separately tried by the government. So I would only say that in the instant case, the government should petition the Honorable Court that this case should be dealt with separately. Otherwise, every instances of these such incidents of illegality is being clubbed in under one PIL. So I would not like to refer to the PIL, but the instant case require separate to take cognizance of this illegality separately. And maybe the government should petition the Honorable Court and accordingly proceed with a separate case. Otherwise, there will be no end to adjudication process itself. It will itself be considered as a modus operandi to create a delay in the whole adjudication process.
We will not discuss this further as I have already given my decision. So we come to item number 2.
Sir.
Calling attention.
Mr. Speaker, sir.
Allow
me, sir, just 2 seconds. Because there was some, we have deviated from the rules of conduct of business of this House, as per the book.
Will you please state under what rule you are making a point of order?
Sir, let me just say, I can't find the rule, but I know it exists. Honorable Chief Minister in his reply of the education question referred to you as Mr. Thomas. Sir, in this House, we do not refer to the Speaker by name or any member. Therefore, that is an irregularity which has to be corrected, because the rules of conduct of business does not allow that. Maybe the Honorable Chief Minister, in his exhaustive reply, made this statement. Therefore, this, whatever was said as Mr. Thomas, let it be expunged so it doesn't form proceedings of the House. That is my request.
We will examine it. So we come to...
So we can change the name to Conrad maybe.
No, it's not a joke.
No, sir, I take it. I thank the honourable member for bringing this to our notice, and definitely, sir, the decorum and the rules must be applied, and therefore, sir, as suggested, the decision will be yours, sir, final. So, as I said, we can change the name, and you can add. But my point was to make a point about the whole aspect of ad hoc schools.
As I said, we will examine, and I will come back later on. So without wasting any more time, we come to item number 2, calling attention tabled by Sri Livingstone Karpran, MLA, under Rule 54(1) of the Rules of Procedure and Conduct of Business to the news item published in U Maufor, dated 30th January 2026, under the caption, Dhaka Police Report na Silchar yo Room ki Khar Bangladeshi sa Modern Kneng. Sri Livingstone Karpran, MLA, please.
Thank you, Mr. Speaker, sir. I arise under the Rule 50, Sub-Rule 1 of the Rules of Procedure and Conduct of Business of the Akas House to call the attention of the Honorable Deputy Chief Minister in charge of Home to the disturbing report published in Maufor dated 17 December 2025. Not 30th, sir, not 30th January, but it is 17 December 2025 in Maufor. This is regarding the arrest of around 10 suspected Bangladeshi nationals and monitoring who were reported on their way to work in East Cheche Hills. So as per the report, these people were carrying police verification documents from Silchar, Assam, and claim to be residents of Assam. However, it is very alarming, sir, that none of them can either speak Assamese or Hindi. That is the report. At the time of investigation, they did not have labor license, valid labor license. Even more concerning is that the labor licenses were issued within a few hours after police verification, raising question on the robustness of our verification system. So, Meghalaya is a border state, international border, and such dissident really demand there is a need for strict enforcement of existing protective laws. As you know, the last few months, there was political instability in the neighborhood country. That's why this incident has taken place. We never know in future, whenever there is political instability in the neighborhood, take place again. If the government could have implemented MRSSE, this could have helped to monitor and regulate the entry and stay of the non-residents. I thank the concerned NGO, HOIDC, Mount for this particular incident that have detected these people. So I want to seek some clarification from the government whether this MRSSE is being enforced or not, or to be enforced in future. Number two, what are steps being taken to strengthen labor license verification, including coordination with other state or neighbor state? I open the government to act decisively so that such incident will not happen again. This is my submission, sir. Thank you.
Minister in charge to reply, please.
Mr. Speaker, sir, at the outset, I take this opportunity to thank the honourable member of this August House, Shri Heavenstone Karpran, Honourable MLA from Mount constituency, for tabling this calling attention notice under Rule 54.1 of the Rules of Procedure on Conduct of Business under the caption Dhaka Police Report Nasil Shario Rumki Khar Bangladesh Shamarang. Dhaka Police Report Nasil Shario Rumki Khar Bangladesh Shamarang Keneng. Sir, on the 15 December 2025, information was received from the President of the Hinyautrep Youth Development Council that some persons suspected to be illegal migrants were detained in a vehicle at Thang Salai Bypass, Maurungkeneng, East Kasils District. On receipt of the information, police personnel from Maurungkeneng Police Station were immediately deputed to the spot to conduct inquiry and take necessary action. Sir, upon inquiry, it was found that 7 persons, along with the driver of the tourist vehicle, bearing registration number ML11B 7533, had been detained by members of HYDC. These persons stated that they were residents of the Hubri district, Assam, and were traveling to Sokilo, East Janti Hills for work at a construction site. Mr. Speaker, sir, the police verified their identity documents and it was established that all 7 persons are Indian citizens. Though they were initially unable to produce their labor licenses, the matter was verified with the Labor Department, which confirmed that all the concerned laborers possess valid labor licenses issued through the concerned contractor. On completion of due verification, all the detained persons were released. Sir, it was also reported that the driver of the vehicle and some of the laborers were allegedly assaulted during the incident, for which medical treatment was provided at Maurungkeneng CHC. Subsequently, a written FIR was received from the President Yatli Lang Driver Association, and a case has been registered at Maurungkeneng Police Station under relevant provisions of the BNS, and investigation is presently underway. Sir, I would like to inform this August House that to address the challenge of illegal migration and recognizing the need for robust border and internal security management, the government has put in place a comprehensive and multi-layered anti-infiltration mechanism through the Anti-Infiltration Directorate and the district police units. Sir, at present, 18 anti-infiltration checkposts, check gates and land custom stations are operational at strategic locations along the interstate and Indo-Bangladesh borders. These are supplemented by anti-infiltration special squads functioning in all districts, which regularly conduct anti-infiltration drives, surprise Naga checks and patrolling in vulnerable areas, in close coordination with the Labor Department, village defense parties, and the local authorities. Sir, 11 district task forces have been constituted across the state to detect and deport illegal foreign nationals through regular checking and coordinated enforcement involving other departments. Mr. Deputy Speaker, sir, These 13 measures have resulted in significant detections and enforcement outcomes from 2021 till 3 to 2026. A total of 658 Bangladeshi nationals were detected in the state and prosecuted under relevant legal provisions. During the same period, 194 Bangladeshi nationals were deported after completion of their sentence and upon obtaining the requisite travel permit from the Bangladesh Embassy. Sir, the government has further constituted a state-level committee to monitor detection, identification and deportation of overstaying foreigners in the state. Also, to address concerns regarding illegal migrants influx, the Meghalaya Resident Safety and Security Act 2016 has been made operational in selected localities of East Kasils district. Moreover, provisions of the Immigration and Foreigners Act 2025, BNS, and the guidelines issued by the Ministry of Home Affairs, Government of India, are strictly followed to combat illegal immigration. Sir, the government also appeals to all organizations and citizens to cooperate with the authorities and allow verification to be carried out through lawful means, so that genuine Indian citizens are not harassed, and at the same time ensuring that illegal infiltration is firmly dealt with in accordance with the relevant provisions of law. Sir, with these few words, I once again take this opportunity to thank the honourable member for tabling this calling attention notice. With these few words, sir, I resume my seat.
Now let us come to item number 3, short duration discussion. Sri Abhingston Kapran MLA, theories short duration discussion under Rule 50 of the Rules of Procedure and Conduct of Business regarding the discussion on the ongoing developmental activities under New Shillong Township. It has also been supported by Sri Aden M. Pasamot MLA and Sri Brad Sturwell, Marbaning MLA. Sri Abhingston Kapran MLA, please, to move.
Yes, thank you, Mr. Deputy Speaker, sir. I rise to raise a short duration discussion under the Rule 50 of the Rules of Procedures and Conduct of Business on the ongoing developmental activities on the New Shillong Township. Sir, the government of Meghalaya has undertaken so many developmental activities in New Shillong Township as major initiatives to congest the existing capital, to establish a modern, administrative and institutional hub. The development of New Shillong has a direct and significant bearing on the surroundings, particularly some villages. These impacts relate to the land use, water resources, environmental sustainability, traffic movement, public utilities, and socio-economic condition of communities. So I made it clear why I raise this matter is not to hinder developmental process in the New Shillong, but to facilitate constructive discussion in the House and to let the people know what are going on in the New Shillong. To see that the implementation of different developmental activities in New Shillong proceeds in a manner that is transparent, accountable, environmental, sustainable, and socially inclusive. So I have the list of 11 projects going on in New Shillong, but I need some clarification from the government. Number 1, New Meghalaya Secretariat Complex, Umsoli. Project cost 1,188 crores. Land area 53 acres. Status under construction. Target for completion mid-2027. So it is a challenge for the government whether they can complete this big project by mid of 2027 next year. The key components: phase 1, 68 offices, facilities for 1,829 staff, 100-seat auditorium, phase 2, 56 offices, facilities for 4,746 staff, 2 auditoriums, 200 seats each. Purpose: to shift the entire state administration to New Shillong, decongest existing Shillong city, get modern administrative hub. Number 2, internal trunk road network, New Shillong. Project cost 2,000 crores plus. Scope: multi-lane roads, footpaths, dedicated cycle tracks, utility docks, and storm drainage. Coverage: connect Secretariat, Unity Mall, Knowledge City, Prime Hub, Heliport. Number 3, New Shillong connectivity roads, 3 mature corridors, total length 16 kilometers, total cost 49 crores. Key routes: Polo to Belfon, Maupat to Nongkwalo, Lumling Side to Shillong Bypass, Southern Bypass, Molongat, Makasiang, Mau Shibuit, Modern Ray. I want to know the status of this Southern Bypass. The objective was for the traffic decongestion, fast access to New Shillong, reduce pressure of existing Shillong roads. Number 4, Unity Mall in New Shillong. Status, as far as I know, under construction. So, number 5, Knowledge City, Maukanu, Maupang area. The area of this project, Knowledge City, is 807 acres. So I want us to know whether this area falls under agricultural land or non-agricultural land. The developmental focus: education, research, information technology, tourism, sports. And facilities: university, research center, and innovation hubs, sport infrastructure, tourism development node. Number 6, Meghalaya skills and innovation hub. Purpose: skill development, entrepreneurship, startup incubation, youth employment generation. Number 7, Prime Hub and commercial zones. Component: business centers, office spaces, commercial blocks, hospitality, and service sector infrastructure. I don't know whether this project has started or not. Number 8, Heliport, New Shillong. Objectives: VIP movement, emergency services, digital management, tourism connectivity. Working women hostel. Purpose: support working women, safe accommodation, near administrative zones. Number 10, Central Jail relocation project. Land acquisition, 35 acres at Ring. The purpose: to shift Shillong Central Jail, enable administrative Knowledge City corridor, improve security and urban planning. Last, integrated corridor, administrative city, Knowledge City. Purpose: seamless movement, infrastructure continuity, future metro mass transit planning. So the total investment outlay in New Shillong already planned 5,500 crores, expected total investment 15,000 crores. So this is my submission. So I would like to know from the comment the status and the progress of these projects. With these few words, thank you, sir.
Any other member who would like to participate?
Sir, I want to participate in this short duration discussion, and I must thank the honorable member from Morongkeneng who has brought this short duration discussion on the rules 50 of the rules of procedure and conduct of business regarding the ongoing developmental activities under New Shillong Township. Sir, I am very happy to see the change of that area, New Shillong Township. People who have not seen that area, they may think that it's only a dream. But I would like to request everybody, especially the members of this Akos House, to go and visit once of the New Shillong, to see by our own eyes the change, the big change that has taken place in those areas. I'm very happy to see this short duration discussion has been brought today in this Akash house, because just last week I happened to come there and to drive to all those roads, 4-lane road. And initially, people, they will fail even to understand that why so big road in the midst of the place where no houses, no inhabitants, but there's so many big roads. But we see the wisdom of the government to build the road first before other activities come. And we have seen also so many activities has come up, like the administrative block, the secretariat that is the government is planning to shift there. And we have seen the assembly also is about complete. So many activities we have seen from the government as well as, the state government as well as the central government, the activities that has taken up in the new Shillong township. I am very sure, sir, that if people of the state visit that area, they will be happy of our own government, and instead of crying, instead of blaming the government about the development, we should appreciate the government when we see how the government has brought so many changes in the new Shillong township. I wish the government all the best to complete all these activities as listed by the Mubar himself. He has listed so many activities that the government is planning to do there. We understand the fact that it is not possible to complete everything in short time, but it is very good, the plan of the government, the wisdom of the government to complete one after another. And I have no doubt, sir, to see the light of the day that Shillong city be shifted successfully to the new Shillong. Even though we have only one concern, that the traffic jam in Polo market while going to that side, till now we don't see the solution how to get the road, because it was so congested in this portion from Polo to Demsonyang. It's very congested, and we don't see till now how the government can solve this, because this will be the main road, the main connectivity portion to connect the old Shillong and the new Shillong. So I would request that while taking all those activities in new Shillong, I will be very happy to see also that the government plan to solve this problem, whether by having the flyover from old Shillong to new Shillong, so that we avoid those traffic congestion at Polo Bajar and Demsenyong. So this is my advice to the government, to try to find out the ways and means. Even though we have seen that they have planned to make road through Maupat to New Shillong, yes, that's very good. The government is actively involving to make road from the other part, from Mauro side to go to New Shillong. But we know that the maximum people will be traveling from this portion, from Polo Bajar, Demsenyong to go to New Shillong. So my request to the government to try to find a way out so that we are clear that we can reach New Shillong in a very short time from Old Shillong. That is my submission, sir, while taking part in this short duration discussion. And with this few words, I conclude my speech. Thank you.
Mr. Deputy Speaker, sir, I'd like to participate in this short duration too. So this new Shillong development of the various infrastructure that is coming there is very commendable, and I thank the government for having brought all these infrastructures to this place. I represented Sorongham constituency from the year 2003, which is now Morakning, for 2 terms. And the constituency started right from Umpling, Ichirwat, all the way to Dengposo and elsewhere. I traveled on a road that was built recently from Maupadang to Ummir, to Maushoro, to Mautumtum, to Maukonu, connecting the bypass to go to Umroi Airport. It took me only 45 minutes. beautiful road. And all this infrastructure has really brought a lot of development to the villages, right from Ishirwat up to Charwai. This whole area, sir. I used to travel, sir, those days to visit the constituency only during winter, because the roads were so bad that you would need a four-wheel truck, not a jeep, four-wheel truck during the monsoons. Today, every village has cars. And I remember when we used to go, the villagers were all cultivators, farmers. When we come back, our vehicles used to be full of vegetables, pumpkins, tomatoes, the local produce. But today when you go, you come back with nothing, because they have sold it, because the buyers from various places go to the village. It's so easy to reach now. You will get a cup of tea, no doubt. But besides that, what point I'm trying to raise is, infrastructure, road development, the government has done a beautiful job that we cannot deny. And I thank this government for looking towards New Shillong. In 2004, sir, when we were in the assembly, that was at the State Central Library, the choice of constructing the assembly building then was the same venue where it is now being built. And it was under, the land was under the Urban Affairs Department, if I recall correctly. In the house I spoke. I said, why don't we build an assembly building there? At that time, I think we had 40 ministers in the cabinet. I was one of the ministers also. But then subsequently, due to downsizing, I was thrown out. But that's besides the point. Then, I will not name the member of the House who's not here today. He said that Charles Pongrove wants the building there because that is his constituency. So I had to shut up, keep quiet. But now, sir, one request I have, that if the government, like as mentioned by honorable member from Mogurwat, Barrington, I think he also lives in the Moroccan constituency now, right? I know that. That we have a road from Saulad, Mranting, from there all the way to via Supakeh, all those places via Lapalang, Nongra, yes sir, Feeder Road, Ishirwat, connecting this New Shillong. That road needs to be taken up, the acquisition of land, because it will be a very difficult proposition in the days to come if you don't take this up seriously. I have been also told by the people who travel, entire people who come from Jaintia Hills, from all the different constituencies, they have to go that road to reach Nigrims and subsequently now New Shillong. One side we have some defense land, the other side is some private and MTC and all that. So if we can take up a proposal, I wanted to discuss that in the motion also, for decongestion and expanding, then travel to New Shillong and all the projects that are coming up there will be very easy. So once again, sir, we are not criticizing nobody here. In fact, we are thanking. But these additional exercises which has to be taken to make the New Shillong more accessible to the public freely should also be taken into consideration. Thank you, sir.
Honorable Minister in charge to reply, please.
Mr. Deputy Speaker, sir, at the very outset, I would like to express my appreciation to the Honorable Member from Morangkeneng, Honorable Member from Nong Thomai, and Honorable Member from Mokorwat, for having tabled and participated in this short duration discussion in this House. So Shillong is growing rapidly, which of course is bringing pressure like congestion, limited parking, stressed water and drainage system. And these challenges are made harder by our hilly terrains and limited land. But we are tackling them with a clear and a phased plan. Today, small steps like street vending has been organized, with hawkers shifted to safer designated zones. A new city-wide fleet of 120 buses, including electric and AC buses, is being rolled out. The river rejuvenation, drainage cleaning, public space improvements are underway, and parking is being addressed through regulated on-street parking and 11 upcoming multi-level car parks. With Shillong population now exceeding 5 lakhs, so we need two-pronged approach. One, solve today's problem in Shillong, and two, build tomorrow's opportunities in New Shillong. So as we are all aware that we have set ourselves a target of building a $10 billion economy by 2028. And the economy rests on several pillars. One of the central ideas is to create a strong growth hub that can drive jobs and investment. So between 1995 and 2007, 915 acres were already acquired in Maudiandiang, Maukasiang, and Umsauli under Muda. Post-pandemic, we have been completely focused on transforming this idea into a functioning reality. We have operationalized, funded, and accelerated these developments. Sir, more than 6,000 crores has now been sanctioned for this development, for these development projects, with nearly 30% already spent on ground level work. Development is progressing in a phased-wise manner. Phase 1 is the administrative city, 915 acres, Maudiandiang. Phase 2, the knowledge city, 807 acres, Maupadang, Maukanu. Phase 3, Tinring, 50 acres, which will connect both Phase 1 and Phase 2. Phase 4, transit-oriented development, corridor connecting the growth centers with highly efficient and reliable transport. In short, New Shillong is being built as Meghalaya's engine of growth, powered by 4 pillars: tourism, sports and culture, education and skilling, and technology. Together, these sectors will attract new industries, create new opportunities, and generate over 1.5 lakh jobs, making New Shillong a true hub of employment for our youth. So let me begin with the Shillong Master Plan. In simple terms, the Master Plan tells us where the city should grow, where it must not grow, and how we protect our hills, rivers, open spaces, and neighborhoods. This plan, prepared by NESAC, covers the entire Greater Shillong planning area, about 288.5 square kilometers. Sir, for the first time, using GIS technology, a risk-informed approach identifies all flood-prone and landslide-prone areas and restricts unsafe development. What is important to highlight is that the master plan was shaped with strong community participation. About 15 Dorbar Shnongs from Sarang, Saisej, Maulong, Lunjeng Yen, Mokenring, Lumse, Wamin Tait, Kirdeng, Mokuduk, Molong Hared, Nongra, Maonyang La, and etc. I'm sorry I didn't get all the pronunciations. I do apologize. These have expressed concerns, and I sincerely thank them for their valuable inputs. All their suggestions were carefully reviewed and incorporated before the plan was finalized. In addition to this, to ensure safety, the bylaws now ban construction on slopes steeper than 50 degrees, preventing haphazard hill slope development. A comprehensive mobility plan completed in 2024 lays out a 30-year mobility roadmap. Based on its recommendation, a structured, well-connected grid of major roads such as Umwir Maukunu, Polo Umsauli, Maupat Umsauli, Maukasyang, Maujenjang Maukunu, Maulingad Maukasyang corridor, along with internal roads, 4 networks have been planned to ensure smooth movement within New Shillong and seamless connectivity to the mother city. So also additional information, of course some are repeating from here, but as per information which was shared to me by the Honorable Deputy CM, that the Polo Mauro connecting to Belfont, this is actively under consideration. MEC to Umpling Bridge, this will be taken up under the World Bank. MES to Umpling, the bridge. Rinja, Nongra, Molinri and Maukasyang, to Maukasyang. This is an intermediate road. This also will be taken up. Survey is on to create the eastern bypass starting from Sorankam, Maushibut and Maulinri connectivity to Maukasyang. At the same time, the Saulad Madanriting Super Care is also under active consideration by the PWD, and I should say it is also in the pipeline. The 10.95 kilometers Umwir Maukanu Road at 201 crores is completed. Other stretches are progressing. New Shillong also lies along the proposed Guwahati-Shillong-Silchar high-speed corridor and benefits from the upgrading of the Shillong airport. This positions it as a regional growth center connected to tourism zones like Umyam Lake. So when we talk about building a new city, the first question that naturally arises is, will there be enough water? We recognize that the development will extend beyond government-acquired land. and that growth will also take place in the surrounding communities. Keeping this in mind, the PHE prepared a DPR for the water needs of 32 villages such as Maupadang, Minriang, Diangpaso, Jaroit, and other villages in the region. The new system has been designed to provide 56 million liters per day for 4 lakh people in the region at 135 liters per person per day. The phase 1 of the project, costing 544 crores, has already been sanctioned in 2024 and is under construction. The project draws water from the Waumken River and includes a dam, jackwells with pumps, houses, and an approach bridge. So this is planned development, relying on sustainable surface water, proper storage, and scientific management, while avoiding tube wells that would deplete groundwater and harm our communities. New Shillong's power system has improved sharply with the new 33 kV Umro substation, expanded 11 kV lines, and installation of transformers, cutting outages in areas like Maukasiang from 63 hours to under 6 hours a month. The new 33/11 kV assembly substation is nearing completion, with upcoming 40 MVA substations at Maukanu and Umsauli. The city will have a strong and reliable power backbone for future growth. So the master plan for the government acquired land at Maukanu and Maudendiang has been prepared using same scientific and careful approach. Detailed studies of the terrain, including contours, slopes, hill profiles, wind and water flow, and rainfall, were carried out to ensure the designs work naturally with the landscape and prevent issues like flooding and waterlogging. The entire plan follows the URD-PFI guidelines, ensuring a well-organized, environmentally responsible, and future-ready township. Phase 1 of New Shillong, the administrative city, has grown into a strong center for education and public service, with institutions such as IIM Shillong, NIFT, NEIAH, and NIGRIMS, creating a powerful knowledge and healthcare ecosystem. The area is also witnessing significant commercial growth with the upcoming Unity Mall and planned commercial streets. It is becoming a vibrant urban hub. Just yesterday, sir, in your presence and in the presence of the Honorable Speaker, we had a meeting in the new assembly, proposed Assembly Secretariat building, which is very, very near completion. And I have requested, Honorable Speaker, that the annual Finance Minister's lunch that we give from the Finance Department, being the budget session, if that could be held in that new complex, which would allow our members to see what has come up. And sir, you saw it, but most have not seen yet, that it is really a remarkable structure. A structure with very, very modern designs and interiors. We are very hopeful that very, very soon, I don't want to say or give a commitment, sir, because it is your domain, but we are very hopeful and very soon, that very soon we will be able to enter the new assembly building. And as I said, even the works are going on at a very fast pace and only final aspects are left. But again, it's another indication of the commitment that this government has towards ensuring that not just in our proposals and in our speeches we make, but also in our action, that we show our commitment towards making New Shillong the center of the growth for our state in the days to come. So a major focus in phase 1 has been creating an inclusive and balanced urban environment. Around 64.9 acres have been earmarked for new higher education and skill institutions. The IT park has already generated employment for more than 1,500 young people. Housing is a key component, with 51.68 acres allotted for residential development, including 10.9 acres for affordable housing with 435 planned units. Sir, I want to share with this House that while our state is growing and while we are making investments in key infrastructures, the government is also aware that we cannot leave the marginalized section of society out. And therefore, as a part of the development of the new administrative city, 10.9 acres of land will be utilized for affordable housing that will be given to the economically weaker section of our society. And this will just be the beginning. We feel that there are many people who require housing. There are many poor and economically marginalized families in Shillong city and in our state as a whole. And therefore, this is a humble beginning of 10.9 acres. I hope that this also will be one of the key drivers and key structures for us to ensure that we are able to provide affordable housing to as many people as possible, as I said, especially to the weaker section of society. So to show our commitment to that, we have already identified 10.9 acres where affordable housing for 435 planned units will come up. So the master plan ensures adequate social infrastructure with schools, community facilities and green areas, supported by initiatives like the 10,000 sapling cherry blossom plantation drive to maintain strong environmental qualities. In phase 2, the knowledge city at Maukanu is being developed as a land of opportunity for our youth, driven by major investments in education, technology, sports and culture. This phase will include a major IT park, skill and innovation hub, and landmark cultural and sporting assets such as the country's tallest monolith tower and India's largest 40,000-seater dedicated football stadium, with the Northeast United Football Club's training and center of excellence. These developments will create vibrant new economies and will generate new jobs and opportunities for local people. Phase 2 has been designed with strong emphasis on environmental sustainability, community space and job creation. The plan provides 85.9 acres of parks and open spaces, more than double the requirement. The layout promotes walkability with pedestrian and cycling infrastructure along all major roads. Land has been set aside for hotels, a world-class convention center, service apartments, offices, and mixed housing, including housing for the economically marginalized section of society, much of which will be developed under PPP mode to generate large-scale local employment and make the knowledge city a major growth engine. So we recognize that development cannot be confined only to land acquired by the government. In the town and country planning scheme, we have created a unique mechanism through which traditional institutions and local communities are formally represented in the local area committees, which will plan development for the locality in a collaborative manner. So the new Shillong is being undertaken with vision, scientific planning, and strong safeguard. It is environmentally responsible, socially inclusive, economically transformative, respectful to local communities, and designed for long-term sustainability. The government remains committed to ensuring that the people of Mawangkanaing and all surrounding areas benefit directly and meaningfully from this development. Sir, the honourable member who has initiated the discussion had also mentioned about different projects. I have, in my main reply, tried to cover some of them, but I also would like to share that the construction of the Unity Mall and infrastructure is going on in full swing, where 43% of the physical structure has been completed. Similarly, the construction of the new secretariat at New Shillong, I'm happy to inform the House that in a matter of 3 to 4 months' time, we have completed 35% of the structure. We are hopeful that we will be able to complete it as per the scheduled time, which is sometime in the mid of 2027. But of course, we will stick to our commitment and the lines, and we will work towards achieving those goals. Similarly, sir, the other projects also, including the football stadium, is also going on in full swing. And there is a plan to obviously include a large space for a dedicated space for performances, for large public gatherings, for large church or religious gatherings, or any kind of public event that is required. A dedicated location is also being developed in Maukanu, which will be accessible through the express highway and then can have access throughout the rest of the region. And that also is part of this plan. As I mentioned earlier, we have also planned a hotel, and there is also a large plan for large recreational golf courses, as well as plans for having investments in different kind of aspects of film making. So a possibility of exploring the possibility of having a film city out there is also being examined by us. So therefore, all these developments are on the card. Most of them are happening. And as correctly mentioned, sir, that our commitment is there. We are seeing the changes that are taking place. And I'm very hopeful that with the airport also, as you are aware, I just want to share with the House, the tendering process of the airport expansion has already been completed. The airport authority has already allotted the work, and we're just waiting for some minor permissions from some of the departments, mostly forest related, which take their normal time, which should be done very soon. And once the airport, which I've always believed is maybe going to be one of the biggest game changers for us as a state, is also on the cards. So when you put all of these dots together, we're able to see the future and the plan that is going to develop for the state and for the youth as a whole. And we are again reaffirming our commitment to ensuring that the project and the overall development of New Shillong moves ahead at a strong pace. And all the suggestions that have been given by honorable members today, we have noted all of them down. To conclude, I want to mention what our honorable member from Maukurwat had mentioned about the road connectivity. So there will be multiple connectivities that will be connecting the new Shillong and the current Shillong city. So we are mapping in such a way that people will be able to enter the administrative city and the knowledge city from different sides, and not just from one road. So therefore, there are many. Some of them I've mentioned to you. Some of them are in the planning stage. So I will refrain from mentioning them as of now. But we realize that without having a 4-lane connectivity, or as you mentioned, an elevated road connectivity to the Shillong city, new Shillong city, then it would be, quite difficult for people to come in there. So therefore, those all are being worked out, and we're in very, very advanced stage of finalization of some of the very critical ones. And one major one is there, where we expect a direct route that we will get all the way 4-lane connectivity going straight to the new secretariat. So that is on the cards, but I'll refrain from going into details of that because we're still working on it. But we are hopeful that within this calendar year or early part of the next financial year, all those roads should be finalized, and we should be on our way to making, as I said, Shillong city, the new Shillong city, the city that we all desire it to be. So with these few clarifications and also the information on different aspects of the new Shillong city, sir, I hope I have been able to satisfy the honorable members. And with that, sir, I would like to resume my seat. Thank you, sir.
Thank you. Now let us come to item number 4, motions. Now we'll take up the special motion to be moved by Sri Aden M. Basamut MLA. This House do now discuss in the increasing alienation of tribal land in the state. Sri Aden M. Basamut MLA, please.
Thank you, sir, for allowing me to move this special motion that this House do now discuss the increasing alienation of tribal land in the state. Sir, this is a very important issue, and in fact, the problem that the people are facing in view of the increasing land alienation is quite alarming. So before I proceed with my submission, I would like to, for the benefit of this August House, reminded what land means to the tribal indigenous people. So for indigenous people, land is life, and not only livelihood. You take away our land, you erase our history, culture, and future. Land to the indigenous people is not a commodity to be sold, but a heritage to be protected. Land for the indigenous people is not merely an economic asset, so it is identity, dignity, and existence. Land for the tribal people is not just soil. It is sovereignty at the grassroots level. It is a sacred inheritance passing down through generations. So it sustains not only livelihood, but also tradition, custom, social security, and communal harmony. Therefore, sir, if we fail to protect it, we fail our ancestors. We betray the future generation. So today I stand here not only to speak, but to sound a warning. So the framers of the Constitution of India, in their wisdom, placed tribal areas under the protective framework of the 6th Schedule, precisely because they understood that tribal land cannot be governed by market forces. So under Article 244(2), the Constitution of India and the provisions of the 6th Schedule were granted us special constitutional protection because the framers of the Constitution recognized that tribal land is unique. So the 6th Schedule was not charity. It was a constitutional shield. It empowers the district council to regulate allotment and occupation of land, management of unreserved forests,
control over shifting cultivation, protection of customary laws. And so this is not symbolic autonomy. It is a substantive constitutional power. So therefore, sir, land is not for sale. It is our constitutional rights. So if despite these protections, community land is vanishing, then we must ask, where is the enforcement? Where is the political will? And where is the accountability? Today, what do we see? We are witnessing community land being fragmented. Powerful individuals capturing common resources. Traditional institutions weakened or bypassed. Increasing alienation of community land. So weak documentation and lack of transparency in Raj, Ilika and Hima lands. Encroachment and concentration of land in the hands of a few, and erosion of traditional safeguards. So development must not come as a cover for land capture. Investment must not become an excuse for dispossession. So, in Khasi Hills, land is broadly classified into three categories. Firstly, the Rikinti or private and individual land. Secondly, Rirai, which is a community land. And thirdly, Rikur, which is a clan land. So, among the Khasi community, the traditional landholding system itself reflects this philosophy, and that is, no Khasi is meant to be landless. This system ensured social equality. It granted that every individual, even in death, would have a rightful place in the community burial ground, such as Kalom Jingtep Raj. So this is not merely land administration. This is social justice embedded in tradition. It reflects the sacred and collective ownership of land. And it is the depth and civilizational respect for land. So, sir, if community land disappears, then our constitutional autonomy becomes hollow. If right land weakens, the foundation of our traditional governance weakens. Again, development cannot come at the cost of dispossession, sir. Progress cannot mean erasure of identity. Growth cannot justify cultural extinction. So today, we are witnessing a deeply worrying trend. The increasing alienation of tribal land. This alienation is not confined to transfer to non-tribal only. More dangerously, community lands, which is right land, Ilaka land, and Himalayan, are gradually slipping away from the very communities they are meant to belong. It is encroached upon, manipulated, or concentrated in the hands of few powerful individuals. So therefore, sir, it undermines the very spirit of our customary system. And that is internal colonization. So this is not development. This is dispossession by design. So the emerging pattern resembles organized exploitation, where influential groups take advantages of legal loopholes administrative silence, or weak enforcement. So therefore, sir, I feel if the state remains passive, history will judge us harshly. So, sir, there is also a connivance among people in power, district council, traditional heads, officials in the Deputy Commissioner Office, Revenue Department. So, sir, if we allow right land, Himalayan, Ilika land, sir, to disappear silently, then the sixth schedule becomes meaningless. It becomes a decorative provision in the Constitution rather than living protection, sir. The Constitution has already given us power. Failure to use that power is not helplessness, sir. It is negligence. So therefore, it results, number one, sir, weakening of traditional institution. Number two, loss of collective ownership. Number three, rise of inequality within tribal society. Four, conflict between communities and authorities. So a case in point. Land in Right Tendring, community land in Right Marwet, community land in Daistong, community land in Lumbangla, and many more, sir. So therefore, sir, I feel this is a very important issue that the House need not only to discuss, to take a very strong step. So as far as Garu Hills is concerned, it has come to my knowledge that Garu Hills is no exception either. The situation is further exacerbated due to the adaptation of the ALRR 1886 by the GHEDC. This has resulted in the conflict between the customary practices and the Assam Land and Revenue Regulation 1886, which was adopted and enforced by the GHEDC in the plained areas of Garu Hills. So in the case of Garu Hills, sir, land has been classified into two categories. Firstly, the hilly lands, and secondly, the plain lands. The hilly lands are controlled and managed by the customary beliefs and practices of the Garu community, whereas the plain lands are governed by the provision of the Assam Land Revenue Regulation Act of 1886, adopted by the Garu Hills District Council since its inception. So the hilly land is known also as the Aking land or the Kalan land. The concept of Aking tenure is based on the inalienable and complete rights of the Aking chief or the Nokma with the members of the Chra and Mahari to act as custodian and guardian of the land. So it is found that the traditional land tenure system provides land to all members of the community, and this has, as I've been told, has knit them together, sir. So the sale of community land is not allowed. An individual household would use the land according to their need or as per the Jham cycle. So a distinctive feature of the traditional communal land tenure system is the role of the community in controlling and managing land, particularly for shifting cultivation. So the management of Aking land is done by the Nokma. He is the leader of the clan and acts as the manager. The Nokma does not enjoy the right of ownership and cannot inherit property since the Garu society is matrilineal. So the members of the clan can use Aking land without paying any rent. And a Garo from another Aking land does not enjoy the same right. It is an Aking Pacific right of land use. So, and there are some changes in the land tenure system of Garo Hills. The Aking land, which were traditionally used for jham cultivation, but after the Indian independence, the JHADC introduced the Garo Hills District Awil Fees. Act 1960 for regulating and assessing the collection of Aking land fees. Timber extraction and all other forests produced are regulated by this act. Accordingly, the arrangement was made that the Nokma collect 25% and the rest, 75%, is accredited to the council. So, sir, the changes in control, management, and use of the Aking land have accentuated and contributed to conflict among members of the traditional institutions of Garo tribe. The new situation in and around Tura has also created confusion about the right and duties of the elders of the owner lineage, and also about the power and function of the Nokma. Now, many disputes have arisen between the Nokma and the elder of the owner lineage about the appropriation of compensation amount. Further dispute have also arisen to whose consent the Nokma should take to dispose of the land. Meanwhile, sir, more and more land is being acquired by migrant families and also by the government, and a sizable portion of the territorial possession of the lineage has now gone out of its possession, sir. The factors are causing a change in the concept of land holding among the Garos and the deviation from the traditional pattern. So, sir, the changes in the customary practices of Aking land are because of various other factors that operate concurrently. Firstly, sir, a sharp shift from jham cultivation to permanent cultivation. Lands are acquired by reclamation from the jungle or by transfer from the previous owner. The Garo Hills Autonomous District Council is issuing annual partas through which the parta holders are becoming owners of that land. This is a shift from the traditional practice of land control and management in Garo Hills. There are some cases where migrants, non-tribals, are occupying lands with legitimate partas issued by the district council. This gives them the right of ownership over the land. So families and individuals are transferring land by selling it off. In some cases, land is gifted. Also, mortgaging of Aking land was noticed. So, as we are all aware, the state of Meghalaya has almost all in its entire territory under the 6th schedule. To discuss land management, land in Meghalaya was traditionally managed under the tribal land management system, where tribal individuals and communities own most of the land. So though the state government had enacted the Meghalaya Transfer of Land Regulation Act 1972, but with amendments made from time to time, there were provisions where a leeway is being provided to circumvent the law and to pave way for the alienation of land in our state. So, when we talk about landlessness in Meghalaya, we all knew, and I had even raised in this August House, as per the report of the socio-economic census 2011, sir. Meghalaya has the highest landless households, especially in rural areas. Only 24% of the household in Meghalaya has land, possess land, sir. So, sir, tribal people in Meghalaya are increasingly become landless and poor as their traditional farming practices are abandoned in favor of commercial plantation. Much of the land, which has traditionally been owned and managed by tribal communities and clans without formal tenure titles, sir. Causes of landlessness are, as I've mentioned earlier, sir. One is the transfer of land. Secondly, privatization of communal land, land alienation, and developmental projects. The Assam Land and Revenue Regulation Act, ALRR 1886, is applied in Garo Hills through the adaptation primarily via the Garo Hills Autonomous District Land Revenue Regulation 1954. And the key issues and conflict with traditional land tenure, legal disputes over patas, cancellation and difficulties in implementing statutory regulation over often community-managed land. So, the problems and the conflicts, especially in the context of Garo Hills, are as follows, sir. First one is a conflict with traditional land tenure, a king system. Let me first speak about the problem and the resulting conflict, sir. The Garo Hills function under the Aking land system, where land is owned by the clan Aking and administered by Nokma, as I've mentioned earlier, sir. Whereas the 1886 regulation assumes state's ownership of wasteland and seeks to create individual pata holders, sir. So the conflict is when the GHADC grants patas land deeds under the 1886 regulation, it often overrides the authority of the Nokma, as the regulation does not fully recognize the traditional communal land ownership structure. Number two, sir, legal discrepancy in land administration. The problem, while the 1886 regulation was adopted by Meghalaya, its application in the 6 scheduled areas is meant to be overseen by the Autonomous District Council. The conflict, there is a clash between the power of the state government on the 1886 Act and the GHADC owns regulation. For example, the Meghalaya High Court had noted that the GHADC has in the past issued land documents without proper consensus, creating legal ambiguity. So, the problem number 3 is the issues with land transfer restriction. The ALRR 1886, particularly Chapter 10, added in 1947, was designed to create protected belt and blocks to prevent non-tribals from acquiring land. Despite these provisions, there are constant allegations of illegal sale of land to non-tribal in areas under the GHADC, including the B Mahal areas. The enforcement of the 1886 regulation has not fully prevented such illegal transfer. Number 4, the GHADC has the power to manage land, but it often operates within the framework of the Assam Land Revenue Regulation 1886, which is the state-level act. And the result is, this creates a conflict of jurisdiction, leading to litigation where the High Court has to determine whether the GHADC or the Deputy Commissioner has the final authority to grant or revoke a pata land deed. So, number 5, challenges to revenue collection and land valuation. The problem, the 1886 regulation, sir, is designed for systematic revenue collection. However, in the Garo Hills District Council, the land records are often not systematic maintained. So, the conflict is dispute arise between the JHEDC attempts to fix land revenue rates or compensate for land acquired for developments as traditional land has no fix with its value in the same which was surveyed privately owned land, sir. So the Guwahati High Court and Meghalaya High Court have noted that while the 1886 regulation is applicable in the state of Meghalaya, its provision must be interpreted in light of the power of the District Council under the 6th Schedule. So the exploitation of the system, the pata system, when imposed on traditional communal land, is sometimes used by powerful actors to acquire land that was meant for the community. So the result is that it had led to protests and legal challenges, sir. So, sir, and this statement which I've made here is also vindicated by the RTI report, which was asked by an MDC from Tura. And in his query, sir, he has clearly asked few questions which is relevant with this issue, sir. The first question which he asked on the RTI is that kindly furnish complete information when Assam Schedule was introduced in JHEDC. Who introduced this to issue pata in JHEDC area? Kindly enclose copy of the Assam Schedule. The reply is records not available, sir. So, sir, the RTI replies speak volume of the fact that there are two authorities. There is a conflict of authorities in as far as the management of communal land is concerned in Garo Hills. Historically and constitutionally, there were only 4 Moses in Garo Hills district, but I was told that the number of Moses, this revenue land, has increased to 10. And now in Garo Hills, the situation is such that the deputy commissioner is issuing pata, whereas they themselves don't have a pata for their own structure, for their own buildings. So I feel that time has come for our state to come out with a very strong mechanism to ensure that community land must be protected at any cost. Coming to Giant Hills. Giant Hills, though they adopted this Assam Land Revenue Regulation 1886, but it has not been directly adopted as the primary land law in Giant Hills. But its principles were adopted through the United Khasi Giant Hills District Land Revenue Regulation 1953. The 1953 regulation adopted the 1886 regulation to suit the local context, meaning it is not a direct blanket application, but rather an adapted version controlled by the Giant Hills Autonomous District Council. In summary, sir, the 1886 regulation serves as the foundational framework, but its application in Giant Hills is managed through the local 1953 regulation frame by the District Council, not like in the case of Garo Hills Autonomous District Council. So, we also know that indigenous people, the Panar of Giant Hills too, have deep connection with land and the nature around them. Very often, sir, when we speak about land grabbing, we tend to think that this is a story of outsiders who grab the land of the indigenous people for their selfish interests, and the case in point are the cement industries in the Narco area. Or it could be also, sir, be a case where a government, be it central or state government, taking over the land of the local people for what they deem to be for the benefit and interest of the people, as happened in New Shillong area. But land grabbing, sir, in Meghalaya also happen in a subtle ways, and in some cases by manipulating the traditional land holding system, which enable clan which are supposed to be mere custodians of the land to claim ownership over the community land. So ownership of land changes hands from the poor and the marginalized section of the society to the elite of the society. It happens in cases where rich coal miners bought the land belonging to poor people, and in some cases when the community forest is sold for a song, sir. So commodification of land, which has for a long been considered as a resource by our ancestors, is happening in the mining areas, and land is becoming scarcer by day, sir. So land which by tradition is considered a common resource is now being commodified, and land ownership is concentrated, as I've said, only among few powerful individuals. The change has not made only many families in the villages landless, sir, but it has also created a division in the community where landless section of society are dependent. So therefore, sir, let this house not be remembered as mere spectator while community land disappear under our watch, sir. Sir, I feel we need and we must immediately, as a responsible government, conduct a statewide audit of all community and customary lands. Digitize and scientifically map Raj, Hima, Ilaka, communal land to prevent illegal transfer. Thirdly, sir, establish a transparent land registry mechanism in order to coordinate and also to coordinate with the Autonomous District Council. So, mandate prior informed consent of affected communities before any acquisition, lease or change of land use. So, strengthen legal safeguard against misuse of customary authorities for private enrichment. We also need to place an annual report before this House on the status of tribal land protection. We must also bring transparency in land transaction involving customary institutions. So, we were elected to protect our people, not to preside over their dispossessions. So, I urge, therefore, this August House to send a very clear message that Meghalaya will not allow the erosion of its community land and customary safeguards under any circumstances. So, the continued alienation of tribal lands has not only disrupted the traditional ownership pattern, but has also triggered steep escalation in land prices, pushing many poor families into landlessness and economic vulnerability. So with these few words, I resume my seat.
Thank you. Any other member who would like to participate?
Thank you, Mr. Deputy Speaker, sir, for allowing me to participate in the special motion moved by Honorable MLA Sri Arden Basamoit, Nongkrem. I am very much amazed at how he described and narrated the history and background about the land holding system in Garo Hills, which is very amazing and I appreciate it. I may not be able to narrate about the Khasi and Jantia brothers, how the land holding system work here, but I will be focusing on Garo Hills land holding system and land alienation which is taking place at present. I would like to throw some glimpse of history in this august house. Land holding system in Garo Hills. The Garos, they practice the system of traditionally owned, which is managed by Nogma, which was rightly stated by the mover of the motion. And traditionally, and today also, it is still being practiced that the youngest daughter of the family, she inherits all the property. After the annexation of Assam in First Anglo-Burmese War and signing the Treaty of Yandabu, the British, they came first to Garo Hills and they annexed the Garo Hills also into their fold. And with that, the land annihilation started. They came and annexed the Garo lands from the Nokma and they introduced a zamindari system. And they started taking taxes from the Garo people, which resulted in the protest. The Garos, they have to pay. They had to pay lots of taxes to the British government through zamindars. It was protested. The first Garo political leader, late Sonaram Asangma, he protested against it. And he even went to court and fought against the oppression and the taxes being imposed on Garo people. Now coming to the present, land alienation in recent times, there are some factors which I would like to mention, like the illegal settlement in the plain area, which the mover of the motion had stated that the Garo Hills consists of two reasons. One is plain and one is hill areas. The hill areas are dominated by the tribal people. And the plain areas are mostly dominated by the non-tribal community people. So these illegal settlers, I would say, when we got this statehood in 1972, we still have that Land Regulation Act, which bars the transfer of land from a tribal to non-tribal and even to non-tribal to non-tribal. But it can be done with the permission of the authority. Now, the problem is those illegal settlers, which I would say, they, as per the Land Regulation Act of Meghalaya, they cannot come and settle in the Moza number 3. But why I am calling them illegal settlers? Because they have entered this Moza number 3, even this Moza number 3, where they have no right to get the land patas, right to even settle, but they have entered into the Moza number 3, sir. So that is why I am saying these people are illegal settlers. Though they may be from our own state, but as per the Land Regulation Act, they don't have the right to settle in those areas. And rampant illegal mining activities, which is being carried out in plain belt areas, adjoining to the hill areas, which we all are aware. In January 9, one precious life was lost because of that illegal stone quarry activities. This type of alienation, and I don't want to dwell much, but there are some points, like Benami transactions are also there in the West Garwils. I'm focusing on the West Garwils. In those areas, some non-tribals, they are buying off land in the name of the tribals. And they are using that land to construct houses for themselves. When the authorities go and check them, they will say that they are taking it on rent. They are not the owner. But in fact, it's very difficult to check them, but it is very much happening. And when we were going to, last time, when we were going to check that illegal stone quarry after that unfortunate incident, we were informed by Rajabala parish, the Chokchokia parish, that their parish land was being encroached. And they asked us to raise this issue so that it can be noticed and necessary steps can be taken. This type of encroachment, this type of illegalities are being taken place in those areas. And I would like to focus on that land bank issue also. Yes, development is the necessity for all of us. It's very important for the growth of the state. But purchasing the tribal land and handing it over to the outside big companies for long years, like 90 years, 99 years, it violates the ownership of the tribal land of tribal people. As we studied in college in the subject of economics, land is not elastic. Yes, it's very static. So in due course of time, in future generation, our population may increase. And in those days, like the mover of the motion has stated, some has already been left rendered landless at present. So in the future, because of the buying of large portion of land, tribal lands, and handing it over to big companies who are coming from outside, it will make the tribal people of Garo Hills landless. So these are the some points which I would like to put forward in this August House, so that this type of problems which will arise if we don't take a cautious steps for future. With this few submission, I would like to resume my seat. Thank you.
Yes, Dr. Mukul.
Mr. Chairman, sir, I would like to rise to participate in this very important matter, issue confronting the people of the state at this crucial moment, and rightfully tabled by our honorable member, Sri A. Basamat. Mr. Chairman, sir, as it is written, refer to Deuteronomy chapter 30, verses 5. Then the Lord shall bring you to the land which your fathers possessed, and thou shalt inherit them. He will multiply you and prosper you. With these blessings, we generate the kind of hope for our children, grandchildren, for generations and generations. And rightfully, I think the people of the state of Meghalaya must acknowledge and confess that the land that belongs to our people is truly a gift of God. And we must protect it. And we must ensure that the children and children, the children's children, generations after generations must inherit this land. And they should multiply and prosper in this land. It is based on this promise that we keep our hope. And we must, therefore, also see that no other forces can alienate us from this hope. And this obligation and responsibility of ensuring that when the forces of darkness act 24/7 to tempt us to make this promise null and void, I think we should fight tooth and nail. And that is precisely the reason why you see, why we see the present resistance to this whole attempt of land acquisition. Land acquisition. Now we must also look at as to who are the powers who are also in disguise by weaponizing the power, creating this alienation of land. Now, if we who are vested with the repository of state power do not utilize this power to protect this interest, then the people will obviously come out to the street. That is what we are seeing. We are seeing number of instances of manner of articulating people's grievances, which come in diverse form. And one of the main triggering factor to generate that kind of sense of frustration, anger, is alienation of land, which is happening just in front of all of us. Now, while there are different laws which has been enacted to protect our people's interests in as far as the ownership of the land is concerned, it has become more important now for us to be more stringent in examining any proposal for any kind of land which may be required for the purpose of any investment. Because the Transfer of Property Act will prevail subsequently after the ownership is alienated. If you go by even the judgment of the Honorable Supreme Court revolving around this coal mining related case, the judgment of the 3rd July 2019, how did we retain the right to own the mineral under the surface of the land? The Honorable Supreme Court contended and in its judgment pronounced the fact that whoever has the right over the surface of the land shall have the right over the mineral under the surface of the land. Based on this only, today, when the overall legal mining process has to be encouraged, this SOP has to revolve around this observation and these relevant acts. And that is precisely why today you see in the case of legal coal mining application, the grantor is the owner of the land, not the government. Because the owner is I cannot grant or be a grantor to a land which I do not own. So this is precisely the interpretation of the law pronounced by the Honorable Supreme Court. And if we see, we should have corrected all other wrongs which still exist and which is still being implemented by the government. Now, if this is not corrected by the government, how will people correct it? We are not all legal experts in as far as the common man is concerned. We are lawmakers, but then people, the stakeholders, in absence of this realization of the government that today even the Honorable Supreme Court has given a judgment which has enabled the people to have the absolute ownership over everything, not over the surface alone, but even on what is there under the surface of the land. Imagine the kind of, the kind of both right and the power that has been vested upon our people. This is also based on our exhaustive exercise and engagement with Government of India. We refer to the relevant para 12 of the Constitution of, 62 of the Constitution of India. We took up the issue persistently, aggressively with Government of India, while trying to get the rights restored to our people, based on which the line ministries submitted before the Honorable Supreme Court that the relevant ministries, there are two ministries who have submitted those relevant affidavits before the Honorable Supreme Court prior to the judgment, saying that this ministry does not have any objection to the proposal of the state government of Meghalaya. Look at the quantum of work we have done to restore this right. Lest what was happening that it was as though the government is the owner, so government gives the lease. Government is the grantor. This is wrong. Now, after the 2019 judgment of the Honorable Supreme Court, all this ownership which has been restored by virtue of that judgment must be implemented in right earnest. Otherwise, all that is being done by the government today is illegal. Yes, it is illegal. Now, if the owner of the land is going to be the grantor in respect of coal mines, why not for the other minerals? How is the other mineral, is there any other act which is applicable in regard to this so-called mining lease to be given? Government doesn't have the ownership, the people. Therefore, it's not just a question of the alienation of the land per se, but also alienation of the power, the right. Therefore, in this particular motion, I would like to stress before this August House that we be all connected with this restoration of right of our people in respect of all those resources under the surface of the land. And that is precisely why we should be very, very cautious. Because once the alienation of ownership over the surface of the land goes out of the hand of our people, then what happens? The right over the mineral under the surface of the land will also get alienated. I refer to the scripture. Because after us, our children shall be brought back, even if they go outside, and they shall inherit the land. And they shall multiply and prosper. Why are we in a hurry? Do we have enough resources to invest and really leverage upon these resources under the surface of the land? No. You want to invest, borrow, investors from outside, invite investors from outside. Look at how logistically Meghalaya is in a very difficult, from accessibility perspective, from logistic perspective. But why investors will not look at Meghalaya as one of the most favored destinations? If we allow through whatever provisions, exemption provisions we are allowed to use, courtesy, whatever is there in the Meghalaya Land Regulation Act, Meghalaya Land Transfer Regulation Act. We need to correct them in view of this ownership which has been restored to our people. Now look at the global power struggle with the Honorable President of US, with his new, aggressive implementation of various foreign policies to really remain both, not only from the perspective of strength from defense perspective, but economically. Trying to look at how he can make other countries bow down to US and agree to all kinds of proposals of tariff war. What has happened with China? Because of the rare earth. Because of the rare earth. The first mover advantage that China has taken globally to take control of the rare earth which is required today. In this era where the technology is fast growing, faster than we can imagine. Because, as I said, the first mover advantage. Today, we do not know what is there under the surface of the land which I own, which the different clans who own the land owns. The Akhung land which is owned by my clan, the Akhung land, for Garo Hills we have Akhung land of almost all the clans. Whether Manda, whether Chambukong, whether your Chada, whether Nengmanja, all clans. Amazing way of gift of God. Similarly in Khasias, you look at every land belongs to our people. Therefore, huge land, big land, in the name of investment, I'm afraid. Because knowledge is power and knowledge can be weaponized. Knowledge can be weaponized, intelligence can be weaponized, and power can be, again, further weaponized. When I don't know what is under the surface of the land, somebody may already know. Courtesy technology, the satellite penetration power of knowing what is there under the surface. Limitless power of knowledge and technology. Thereby, having this advantage of first mover for anybody before our people, before our children can be at that stage. Therefore, there is a reason for us that lots of instruments of reaching out to our people to somehow take advantage of the helpless economic conditions. I saw happening in my own constituency. With pain, I'm telling you, in some of the Akhung land, more than half of the Akhung land is being acquired for whatever we may call for government purpose. Do the people know what is there under the surface of the land? Will the cost of the land be calculated on the basis of that whatever valuable asset is there under the surface of the land? No. Today, Meghalaya is blessed with many minerals, Mr. Chairman, sir. I don't have to name them all. But even much more than the names which we know, there are. Our people will be rich. But we have to allow them to be able to harness these benefits in due course of time when it is right for them. Not for our generation. But if you're greedy and we want everything now, I'm sorry, Mr. Chairman, sir. The generations next will remember us for failing them, for betraying them. There are many other things which require our attention. But this is in a broader perspective. What is going to happen for our future generations in the generations to come? Today, ours is to pave the way for theirs. We give our today for their future. That is how we should look at it. But if we are looking at to see what we can do today at the cost of their future, it is just contrary to what is expected of fathers, parents. Therefore, with painful heart, I see many things happen. You look at how painful it is for people who came and submitted this representation, which has been submitted also to other honorable leaders of the state, whom they think will protect the interests of our Jaipunriyu, our people. I would like to refer to one particular incident which was painfully observed by many of us, which happened on 19 December 2025 in one of the places called DAY-2. We read this news. It was raised even in the parliament by our honorable member of the parliament, Lok Sabha. Why is it happening? Are we not for the people? Government must be seen as protector of the interests of the people. Rather, if government is seen as the power that enables perversion of justice, then people are forced to knock the door of the judiciary. People should not be pushed to that situation when people should knock the door of the judiciary. Rather, it must be the government in power, the authority, in the true spirit of the core values of our democracy, gives all the justice needed. Any possible omission or commission, for whatever reasons, when brought before the government, must be taken cognizance of and addressed in the right earnest. When people complain, they are seen as too weak, because the people in authority try to abuse the power which is vested as a repository of state power in them. People who occupies the position of authority are custodian of the power that is vested on the state. But this is to protect our people, not to force through, not to bulldoze. But if you go by this instance of this particular incident on 19 December, that means the authority is weaponizing the power that is vested upon the authority to bulldoze, suppress, oppress, and grab the land which they want. For whose interest? Are we not to prioritize the protection of our people's interests first? To defend the interests of our people first? But to defend the interests of the people who are eyeing for those land? Mr. Chairman, sir, these are the incidents which reflect the missed priority of this government. Rather than protecting and defending the interests of our people, the government of the day, with all the power under its command, is trying to protect the interests of others at the cost of our own people. Mr. Chairman, sir, our honorable mover of the motion, special motion, and honorable member from Dadingri have rightfully referred to a few other things, including the Benami Transaction Act. We have amended this prohibition of Meghalaya, prevention of Meghalaya, prevention of Benami Transaction Act in the state of Meghalaya. It was amended in 2016. Why was it amended? And in fact, I would like to refresh our memory about one of the measures that we resorted to when we were in the government. In respect of the application of that particular section of Meghalaya Land Transfer Regulation Act. We suspended operation of those provisions which allows transfer for any investment for any proposed industry under the relevant section of the Act in respect of Ribo area. Why was it necessary? Because in Ribo area, what was happening along the Meghalaya-Assam border, and that is one of the triggering factor why, there's land alienation in respect of this bilateral engagement and ultimate attempt to solve these inter-state boundary areas of differences ultimately created that alienation of our land towards Assam, which the government of the day very happily signed. Along the border with Assam, look at the difference of the land costs on the other side of our interstate border in Assam and other side of the interstate border in Meghalaya. Huge difference. Now, in the name of these investments, so many exemptions for transfer of land to companies were given. And these land are being used for other commercial activity, not for the purpose for which originally the approval was accorded. And most of these, again, in the name of various tribals, many land has been bought by people from outside the state who do not belong to the tribal community. In the name of our tribals, Garo, Khasi, and other tribes, some are somebody's driver, somebody's assistant. Therefore, there is a need to go and investigate all this rightful ownership, whether it is by virtue of weaponizing this instrument of Benami transaction. That's why we amended the act. But this act had to be enforced. This act has enough teeth, but unless enforced, where is the deterrence? No deterrence. It continues with impunity. I was pressurized politically to revoke that order after a certain period of time. So I had to do it because pending amendment, just executive order cannot supersede the provision of the law. But if we have done it, it was for a purpose. The purpose was to ensure that there is no further alienation of land to other people from the ownership of our own people. Poverty can be a reason for people to sometimes compromise and surrender. And therefore, everybody cannot sustain hardship. Even if the father is able to somehow resist, then the son-in-law will say, the mother-in-law will be convinced by the daughter. These things we are seeing. I also try to know why in the first instance you all agree. Somebody is there taking advantage of the poverty of our people. Taking advantage of the poverty of the people. What can be worse than this? This is the worst scenario that is happening. In that area where we had this unfortunate incident, where there is a conflict, unfortunate loss of precious life in West Garo Hills. The triggering factor is same. Alienation of the right over the land, abuse of these resources by people belonging to non-tribal community, in violation of various laws. Now, any illegal extraction of mineral, again it is covered under relevant different laws. Again, these laws are also so stringent that they are cognizable offense. But nobody is taking cognizance of these illegalities, as though it is somebody else's job. Cognizable offense is cognizable offense. How many times do we have to be reminded? Just to make it simple and make our people understand about how we interpret cognizable offenses when a person violates the provision of the POCSO Act. Anybody who knows have to report and act. That is what is cognizable offense. Now, in this particular case, number of reports have been sent to the higher authority about what was going on there, about the illegality. No response. No authority, no superior authority took even the necessary responsibility to take cognizance of such reports, which were officially made available. No one was prosecuted. Cases are registered sometimes for the sake of registration. Then the police will submit before the court in view of the lack of blah, 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 no evidence, no substantive evidence to prove beyond reasonable doubt that the alleged illegal activity was committed. Then the petitioner will receive a notice from the court. Why the court should not accept the report from the police? How many people can actually spend to engage with the legal counsel to counter the report of the police? And therefore, this whole exercise, this whole alienation of land is linked and connected with economic activities. Business, which is again indirectly robbing the opportunity of our own people and depriving the state also from precious revenue. But in the instance case, the alienation of the land and the right over the land and the assets and resources is much a crucial issue than even the loss of revenue. When we say loss of revenue is so crucial again, because any act to deprive the state from realizing the revenue that is due to the government, which is supposed to accrue to the public exchequer, itself is an economic offense. But here in Meghalaya, this has become order of the day. It is not a disorder of the day, it has become the order of the day. I was looking at the revenue realization on minor minerals. Realized there's a huge up and down. We always set target. And if target is not achieved, then we do complete, review and find out. Mr. Chairman, sir, while this particular issue of land alienation is being, I think even the mover of the special motion, even when we try to take up this issue in preceding sessions, it is because of how we feel, how I feel, how public feel, how the people of the state feel. The people of the state feel today that land acquisition is also being weaponized with different intent, with different priority. Read between the lines, Mr. Chairman. And if we want to be really honest and really find out what I'm trying to say and vindicate these, then it will be very unpleasant. Very, very unpleasant. Land acquisition is being weaponized. Now, while land acquisition process also needs the authorities to protect the interests of the land owners and the affected people, on the other way around, even in the process of land acquisition for any developmental purpose, whether it is for road, expansion of road or construction of infrastructure, again, victimization of the weak and refusal to give justice to the victims, which amounts to perversion of justice, is happening. People keep on coming again and again to the authorities. Then I am told that, you kindly go and meet so and so. Yes. Whether it is in the matter of acquisition of land for Tura Dalu, that JICA funded scheme. Social impact assessment as per the relevant section of the Fair Compensation and Transparency in Land Acquisition and Rehabilitation and Resettlement Act 2013. It is mandatory and it must be made public. It must be available in public domain. How many such land acquisition process, having embarked upon this social impact assessment, have made these findings of social impact assessment available in public domain? It is our job and responsibility to enlighten our community, our people, so that the knowledge becomes the power to protect themselves. They know. They will know once they know. But then, how many of our people who are affected by this alienation of land during the land acquisition process are aware of the provision of these protective relevant sections which protect the landowners? Unfortunately, no. Now, what does the social impact assessment is expected as per the mandate of the law? Now, I may be the landowner, but if there are 10 tenants in my land and they have livelihood activities in that particular parcel of land, if through land acquisition process, this particular parcel of land goes, then their business is dislocated. To restore their business, how much time, how much duration they will need? Whether they can have same kind of livelihood activity elsewhere. All these things are comprehensively required to be compiled. And accordingly, ensure that this benefit in terms of the compensation, rehabilitation and resettlement is passed on to the project-affected people. This is not done. Why not? Whose job it is to say that, oh, you're being deprived. Don't worry, you will have this, because this is the provision of the law. Same thing is happening in case of this acquisition of land, whether it is Shillong Western Bypass. And I don't know why the alignment of that land, the alignment of that Shillong Western Bypass, which was frozen prior to 2018, was again revised. New alignment. After that, what has happened? The land acquisition process we keep on seeing carried by the media. Some of the people who are affected by this land acquisition have become the victim of this whole process. It is because this provision of law, Fair Compensation and Land Acquisition, Rehabilitation and Resettlement Act, in short we call it LARR 2013. The provision of this mandate of the law, which is designed to protect particularly the tribal people, indigenous people, weaker section of people who are affected due to such developmental initiative and the resultant land acquisition. Through the land alienation, their interests can be protected, their livelihood can be protected and restored. Therefore, what is the meaning of the word resettlement and rehabilitation? Why these two important words? Because there is a need when there is a dislocation of livelihood. Now, this particular instrument of law is enacted and adopted by all of us, because we are the lawmakers. And the moment this act was enacted, we ensured that Meghalaya adopt and implement the provisions of this law. So therefore, in the process of alienation of land, where land is compulsorily required for certain developmental purposes. Let us take cognizance of the impact of land alienation and dislocation of the livelihood activities and see that they are given the kind of support and justice in sync, in conformity with the provision of relevant laws. And there are multiple laws which are being utilized for the land acquisition, not just one law. But the binding and mandatory provision of LARR 2013 is required to be invariably factored while going ahead with the process of land acquisition. And in absence of that, the whole land acquisition process can be declared null and void. That is what the law says. Therefore, Mr. Chairman, sir, I would like to urge upon the government that in those areas where the affected people have not been taken care of due to improper process of LA, particularly for these national highways, it must be relooked. The government must be seen as giving justice. People don't have money to knock the door of the judiciary. It is not affordable. So let there be no insensitivity which will create the perception that government is engaging, the authorities are engaging in perversion of justice. And therefore, with this few submission, I make my points, particularly from the perspective of the grievous harm that will be inflicted upon our generation next if we do not take precaution now. Let this act also be so amended that we can stringently prevent this so-called land acquisition spree. Land bank, land bank. And another point I would like to get from the government is to invoke the relevant provision of section, I think it is section 8. No, that eviction part. There is a provision for eviction of those occupants of our tribal land. Section 8, subsection 1. If any person is found in possession of any land otherwise, then in accordance with the provision of this act, the competent authority may serve a notice upon such person requiring him to show cause why he should not be evicted from the land, and after giving him an opportunity of being heard, require him to vacate the land and remove any building or fences which may have been erected thereon within such time as may be fixed in this behalf. I don't have to go through the whole provision of the law. So, certain provisions, what was felt necessary is to protect the interests of our people. Because when the land is acquired by citing some objective and purpose, if it is not used, it has to come back. But it should not be owned in perpetuity, whether by a corporate or whether by a firm or even a company of the government. Because what happens if the government also holds the land, then there may be a time when by well-determined, predetermined intent, that particular entity becomes bankrupt, so you sell it. The relevant provisions of the company's laws will come. Now there is an attempt by the authorities to somehow reinforce the people with the kind of sense of security that don't worry, it is for the government. Don't worry, it is a government company. Well, company is a company. We have seen all this whole process of disinvestment where government companies are being sold to the private companies. Initially some share, then subsequently some share. Subsequently, finally, the full 100% share. What happens? Alienation. by choice, by weaponizing the provision of the Companies Act. Therefore, there's an indirect way of alienation of land through government also. And sometimes we may be caught at unguarded moment as people who are in authority. That's why whenever these kind of steps are taken, they must be put to stringent scrutiny by the authorities concerned and the public as a whole, lest other forces try to take advantage of a situation of our not being vigilant and allow this illegality to take place. Illegality in true spirit of what is intended by the law. Therefore, with these few submissions, I urge upon the government that look at all those illegal occupations of the land which otherwise belong to our people, which has been occupied by abusing these few provisions of the law and the alienated land are being used for some other purpose. Let this land be restored to our own people as per the provision of this relevant section, subsection 1 of section 8 of the law, and many other law, many other relevant sections, which gives the power to the authorities. Other than that, there has to be some integration with the ADCs, with the traditional institutions, which require more exhaustive discussion and deliberation and debate. To make that we have this sense of oneness when we come to protect the land of our people and see that the promise that God has given us, as written in Scripture, is truly realized by our children. Let generations after generations be recipient of this promise. With these few words, Mr. Chairman, sir, I resume my seat.
Any other member would like to participate? Yes, Bright, sir.
Thank you, Mr. Chairman, for giving me the opportunity to take part in this special motion raised by the mover, Ba Adan Melab Saimoy. I would like to make a very brief submission, pinpointing some of the issues which really concern my community and the state as a whole. In fact, I'm happy that the Honorable LO had raised this issue with regards to the incident that happened at Daistung village. Yes, recently, the issues of tribal land alienation and industrial expansion in Meghalaya have reached a boiling point, centered largely on the proposed Sri Cement integrated plant in Daistung village. At the very fact that the agreement was made by one person from this village with a non-tribal, as far as the transfer of land is concerned, is in direct violation of the Meghalaya Land Transfer Act. And it has raised very pertinent issues as far as the alienation of tribal lands, which occurred time and again in our state. And even it has come to our notice, where recently it was told that in Mausmai, there was one petrol pump that has come up, where one person by the name of Sureka, I don't know whether it is a fact or not, it is for the government to reply, where it has come to our knowledge that the very location where this petrol pump was set up belongs to the government. And how come a non-tribal is being given a plot of land to start a petrol pump at Mausmai? So this has gone beyond when you talk about alienation. It is very sad if it is true that the government of the day are working hand in glove with people from outside and especially non-tribals to take away our land. And as per the DAY-2 incident which had happened, we have seen, everyone, it is in the news, how an agreement was made by one individual on the 6th of October 2025, where 61.97 acres of land were given to one individual on behalf of Sri Cement Limited. And when you look at particularly, I want to stick with this agreement as far as DAY-2 village is concerned, where primarily certain issues and concern that arise out of this. First is which some of our members have raised regarding the Benami transactions and the erosion of customary rights of our very own people. And in fact, our honorable MP had even taken up this matter with the Union Forest Minister, where he had demanded an immediate freeze on the project's environment clearance, citing procedural irregularities. Where when you look at the periphery where this cement plant at DAY-2 is about to be operational, it raised a very serious concern where it might have an environmental impact, where this very area, it is within the area where these heritage caves exist, and the reserve forest, which is very nearby. So I would like to put my submission with regards to this special motion that has been raised, and I would like to support and would like to seek a clarification from the government as far as the government of the day, whether they are aware of such irregularities that is happening as far as this agreement is concerned. So with these few words, I would like to resume my seat.
Any other member? Now I would like to request the Minister in charge to reply, please.
First of all, I would like to thank the Honourable Member from Nongkremba, Adan Milabusomoy, for raising this special motion to deliberate about his point on this floor of the House. I'm very thankful to the other Honourable Member, Rupa Marat, MLA from Dadingri, Dr. Mukul Sangma, MLA from Songsak, the Honourable Member from Molaiba, Bristerwell, Marbanyang, for bringing a point to highlight and know the fact about the land system in the state. When I listened to the discussion, to the point raised by the Honourable Member, that yes, land is a very tricky issue, and the issue of governing the land in the state also, it is a very tricky issue, as elaborated by the Honourable Member, where the clan, the right, the HIMA, the Risk Council, and the private member have a different role in governing of the land and the Risk Council. And it is not very easy for any particular thing to encroach upon the right of the people. But I'm very thankful that till today, there is no forceful encroachment, alienation. All the transfer of land is subjected to the rule of law. So, We know that different district council, they have a different land management system. The Garo Hills, they have the Garo Hills Autonomous District Council Land and Revenue Regulation 1954. The Giant Hills, also they have the Khasi Hills, they have just passed a new act, the Khasi Hills Autonomous District Council Regulation and Administration of Land Act 2021, and the Giant Hills have passed the Giant Hills Autonomous District Council Management and Control over Land and Assessment and Collection of Revenue, Third Amendment Regulation 1985, and so on and so forth. All these acts are meant to streamline the land holding system of the state. The state government in itself is administering only the revenue land, the government land, and also the transfer of land between the tribal and non-tribal. So, having said that, so as we know that Meghalaya was established as a state on the 21st, as the 21st state of India by the Northeastern Areas Recognition Act 1971. The new state of Meghalaya was established on 21st January 1972, comprised in Khasi Hills, Giant Hills District, and Garo Hills District. Under the restriction of the Constitution, overall management of land vested within Autonomous District Council, but the power of the state under the Constitution also exists side by side. However, statutory responsibilities still remain with the government in the Revenue and Disaster Management Department, as also Superintendence of Administration of Government Land. So the Assam Land and Revenue Regulation 1886 was adopted in 1972. The ALRR was adopted by Meghalaya as applicable to all the government land in the state. Certain provisions of the Act are applicable more or less throughout the state, subject to some exception or modification with respect to restriction of land in Autonomous District Council. So, government in various departments has a large area of land spread all over the state. These land are occupied by various government departments and are administered by the concerned department under the general supervision and control of GAD and Revenue. So, the government, there is a procedure how to be allocated, and there is also a procedure how to keep to different departments. So, the Meghalaya Land Survey and Record Preparation Act 1980 provides for the cadastral survey of land in the state and preparation of land record. The Act was amended in 1991 to involve this council in implementation of provision of the Act, as the scheme of cadastral survey has been decided to be implemented by this council with the financial and technical assistance from the state government. So, as you rightly know that most of the land is in administration of this council. So the government from time to time tried to have a discussion with this council to adopt the cadastral survey, because as rightly mentioned by the honorable member from Nongkrem, that there is issue of the occupation of land, or there are some land holding who hold a very large tract of land. There are some who didn't have a portion of land. But this is outside the issue of the government, sir, because as I said, that there is a rule which governs the HIMA, there is a rule which governs the HIMA land, there is a rule which governs the community land, there is a rule which governs the council land, and so on and so forth. So that's why I tell that land holding system in Meghalaya is a very, very tricky issue. I really like the statement by the honorable member LO that more exhaustive discussion is needed if we want to see that the land holding system in the state of Meghalaya to have semblance of uniformity all over the state. But it is easier said than done, sir. Sir, most of the land, when it is registered with the due process of law, as I said before, sir. No land is being acquired without the NOC from the headman or the NOC from the Doloy or the NOCMA, as the case may be. It is, the PATA is issued by GHDC. When we talk with GHDC, it's only on the basis of NOC issued by the NOCMA concerned. So the process of law for registration of land is followed by this council as per their rules. So in the matter related to the raised by the honorable for acquisition of land for highway, honorable from Songsak, so the land acquisition under the, is followed under the NHAI Act 1956. The Commissioner of Division notified as arbitrators after approval of the government of India. The people go to the arbitrator if not satisfied with the award of the land acquisition of the competent authority. But as I said before, sir, whatever we do, it is up according to provision of the law. The honorable from Meghalaya has raised the question of the public hearing in DAY-2. So the public hearing is done as per rule, and it is the DC has submitted the report that everything is done as permitted by the law, sir. So I may bring to the to different departments. The statement by the Honorable
The discussion on the special motion is closed.
Yes, sir.
Which was then facing this, because but then at least some initiative.
But to say that
Which was notified and which was eventually enforced. Then subsequent to that, though in paper they seem to be existing, but there are other areas which are completely witnessing the same kind of activity, where in the name of tribal, some people have started extracting illegally. The records are already available. In fact, the instances of illegality pertaining to this mining of these minor minerals were already submitted to the higher-ups. So that is available on record. So this should be looked into. Because in the slow process of this alienation, it will become, complete alienation in future. And the issue of invoking that subsection 1 of section 8 of the relevant law to evict who are illegally occupied. I think this is big responsibility though, but then at least some initiative should be done. Then another part is, I have referred to the Honorable judgment of the Honorable Supreme Court of the 3rd July 2019 pertaining to the ownership over the land. And the contention of the interpretation that the ownership, whoever has the ownership over the surface of the land also should have the ownership over the mineral under the surface of the land. Therefore, the mining lease cannot be granted by the government but by the owner of the land. So this should be invoked in matter of other minerals, where mining lease is being given by the department, by the government. That is illegal. This goes against this provision of the law and against the judgment of the Honorable Supreme Court. So this is an opportune moment for the government to take rather cognizance of this judgment and restore the right to our people. I think this is where we need to put our heads together. It should be a restoration of right, not just ownership, but right over all those powers which should be vested upon them based on this judgment. So I think the government should take note of this suggestion, because this suggestion is born out of the judgment of the Honorable Supreme Court. So with these few words, I again seek that the government of the day take cognizance of these serious areas of concern where government need to further take course correction and proceed with legal framework in as far as these areas are concerned.
The suggestions given by the LO, I have noted them down. We'll definitely get them examined, sir.
Now the discussion on the special motion is closed.
Yes, sir. Give me a chance to move on. Yeah. So we fully understand that the land issue is very complex. But to say that the government is acquire land through a proper process or legal procedure is an outright
rejection of the fact that there is a growing and increasing alienation of community land. So I don't know whether the Honorable Minister understand or not the concept of community land. It may be under the administration of any authority, but we have to understand that the concept of community land means the land belongs to the people. So my question to the Minister, Honorable Minister, is that, is he aware or sees of the matter that there is an increasing alienation of land? The government cannot shake away the responsibility though. We know there are different authorities that are managing these different types and categories of land. But should we allow that community land is vanishing, gradually disappearing? So whether he is aware or sees of the matter or not.
Mr. Deputy Chairman, sir, I have already mentioned that the landholding system is very complex. But yes, there are many community land in the state of Meghalaya. Sir, but whatever thing they do after consultation amongst themselves, and it is not the privy of the government. The privy of the government is that when all the documents are in place, we have to process it as per rule of the law. Because we cannot dictate the government that don't sell their land, don't construct a house in that land, because that land, they are the authority over the land. But having said that, if by doing that, they contravene the other provision of the law, be the Forest Act, be any act, that the other authority will come into place. But sir, I very much understand the point raised by the honourable member, the mover of this special motion. So wherever it needs, the government will see that the land of the tribal land of Meghalaya is protected as much as possible, sir. Thank you.
Sir, though I'm not satisfied with the response of the Minister, sir, I have another question to the Minister. As far as Garo Hills is concerned, whether the government is contemplating to facilitate, to review the Assam Land Revenue Regulation 1886, which is being implemented in Garo Hills, so that it will not conflict with the customary practices as far as traditional land is concerned. Because this is major problem in JHDC, where there is a confrontation. As I've said during my submission, that the Deputy Commissioner is issuing partas, and the JHDC also issuing partas. So which one is genuine and which one will stand? So may I know whether the government is contemplating to facilitate reviewing that the adaptation of that ALRR 1886?
Sir, to protect the right of the people, it is duty bound by the government to look in all the possibilities, Mr. Deputy Speaker, sir.
Now discussion on the special motion is closed. Now we will take up motion number 1. Dr. Mukulem Sangma, Leader of Opposition, may kindly move the motion. This House do now discuss the style of functioning of the Public Works Department, roads and bridges, with a special reference to the projects taken up under PMGSY, MITP, CRF, and the interested roads and their mode of selection and quality of implementation thereof. Dr. Mukul Sangma, Leader of Opposition, please.
Mr. Deputy Speaker, sir, I rise to move that this House do now discuss the style of functioning of the Public Works Department, roads and bridges, with a special reference to the projects taken up under PMGSY, MITP, CRF and interstate roads, and their mode of selection and quality of implementation thereof. Mr. Deputy Speaker, sir, I have tried to move this motion in last autumn session as well, but because of the constraint of time, this motion got lapsed. Nevertheless, I am privileged to move this motion again, and I have intentionally moved this motion so that the House can have an exhaustive discussion on this very crucial sector of infrastructural development across the state in the best interest of our state and the people as a whole. Mr. Deputy Speaker, sir, as the motion says that this is to discuss the style of functioning of the Public Works Department, roads and bridges, and with a special reference on very crucial interventions, PMGSY, MITP, CRF, and interstate roads, including their mode of selection and the quality of implementation thereof. These are issues which have drawn our attention in as far as the pace of implementation, the quality of implementation is concerned. The state is embarked upon.
Since it is 2 o'clock now, so you can continue with this speech in this motion the next private members' day. Now the House is adjourned till Wednesday, 18 February 2026 at 10 a.m.
We thought we will have some extension of time to allow, because the duration of the session itself is so limited.
Mr. Deputy Speaker, sir, so since you have already given the ruling, maybe let us make sure that the next private member's business be extended, sir.
Okay, done.